Okay, we're going to go ahead and get started, everybody. Welcome to the January 15th, 2020 continuation of the Electoral Board hearing on the Evanston Voter Initiative referendum. Is there a motion to call this back to order?
I motion to call this meeting back to order.
Second?
Second.
All right, all in favor? Aye. All right, the meeting is officially called back to order. I'm going to ask each of the Electoral Board members just to introduce themselves, so everybody in the room, again, and I'm going to ask the same of the petitioner and the objectors. So I'm Steve Haggerty. I'm the mayor of Evanston. For this proceeding, I am the chairman of the board.
I'm Ann Rainey. I'm Alderman of the 8th Ward, and I'm the senior member of the council.
I'm Devon Reed. I'm the city clerk and also a member of the board here.
All right. Petitioners, if you'd like to introduce yourself.
My name is Pat Quinn. I'm the attorney for the petitioners for the Evanston Voter Initiative.
Okay, terrific.
I'm Allie Harnan, principal proponent, but there's a lot of us.
All right, thank you. Thank you, Allie.
I'm Kent Swanson, and one of the objectors, and a registered voter and longtime resident of Evanston.
I'm Betty Hayford. I'm one of the objectors. I'm a member of various organizations, but I'm only acting on my own behalf as an individual and a registered voter in Evanston.
Thank you, Betty. And Jane Grover, objector. And as Betty wanted to say that I'm not here representing any group, including the League of Women Voters, but rather as an individual.
Okay, thank you, Jane. We have with us our stenographer, Emily Pellegrino, who will be keeping a transcript of this evening's meeting. So thank you for being here, Emily. And I'd also ask our counsel for these proceedings, this is for the board, to introduce himself as well.
Hi, Dan Bolin, special counsel for the city and attorney for the board.
Okay. And as I mentioned at the first meeting a week ago, this is a hearing. Okay, so this is different than a city council meeting. There are a set of rules and that referendums have to comply with, and this board is to look at those rules, listen to the expertise that we have around here from both parties, from our city council, or the council to the city board as well, and make a judgment about that. So that is what we will do today. At the very end of this hearing, there'll be an opportunity if anybody wants to speak, sort of at public comment. But that's at the end. It's not part of the record. It's not part of the decision making that's going on up here at this board. With that, I'm going to ask because I want to make sure, again, procedure-wise, we go through everything properly, that the attorney just make sure that I've got everything correct. The first item that we are going to discuss this evening is the petitioner's motion to dismiss the objector's claim. And so that motion, the motion to dismiss, the first, I'm going to suggest to the board, and would like your thoughts, if you guys are okay, to give each party 5 minutes on this motion to dismiss. Okay. On the main arguments, you're each given 10 minutes per the rules. I'm going to suggest on the motion to dismiss 5 minutes, but I want a conversation with the board up here. If you want to do 10, we can do 10.
I think if does everyone feel comfortable with 5 minutes or 10 minutes?
Well, I'm not sure if it's 5 or 10, but maybe it's in between.
I'm willing to split the difference and call it 7. If we can go to 7, I know it's 7.5 for all you out there that quickly do the math. How about we do
I'm
7?
fine with that.
Good with that, everybody? Okay. So we're going to give it 7 minutes, and as I understand it, because the motion was filed by the petitioners, it's the objectioners that get the I want to make sure I get this straight,
That's
counsel, that who goes first? So
Right.
Why don't you take it from here?
Sure. Typically, and that's just my suggestion to the board, is that the movement goes first. In this case, that would be the proponents. Response by the objectors. If you want to reserve time for rebuttal, you can. And at that time, at the conclusion of any argument, if the board has questions, you could ask them of the parties, and then finally, the board will deliberate and make a motion.
Why don't I just suggest this, if it's okay? Because I want to make sure they get enough time to present their arguments and everything, counsel, if we just let them have the additional 3 minutes if they need it for rebuttal. Is that okay with you guys, too?
Up to the board.
Okay. All right, so let's go ahead and get this started.
Okay, well, thank you very much. Appreciate the opportunity to be here. We have moved to dismiss the objection on the grounds that the objection doesn't comply with the mandatory pleading requirements of Section 10-8 of the Illinois Election Code. The code requires a number of requirements for an objection. It is not optional, it's mandatory. Our courts, two appellate courts, one called Pookie versus Cook County Board of Elections, or Electoral Board. In the second case, Daniel v. Daly, have made it crystal clear that electoral boards must understand the code as written. And as written, the code is mandatory. It's not advisory, it's not directory, it's mandatory that each and every one of the requirements of an objection must be met by an objector for it to be valid. In the instant case, the objectors have failed totally to state their interest, which is one of the requirements of Section 10-8. There's no word at any time, the word interest does not appear. Now, our friends, the objectors, are saying, well, it's enough to be a registered voter and a resident of Evanston in order to meet that interest requirement. Unfortunately for them, in the Section 10-8, there is a requirement in order to have standing before this board that the objector be a registered voter and a resident of the political subdivision, Evanston, that we're in today. So they had to meet that. They met that. Unfortunately, they neglected, ignored the clear part of the objection statute, as we've outlined in our brief as well as our reply, that you also have to affirmatively and specifically state your interest as an objector. It's not enough to say you're a registered voter. You must state your interest. It's mandatory. Now, the petitioners in the instant case have followed every single requirement of the election code. They filed their petitions on December 16th. That was within the deadline. They went to the city clerk. They didn't go down to the county clerk. They went to the city clerk of Evanston, and they filed sufficient signatures to qualify this referendum. They followed the rules. The petitioners did. And in fact, because they followed the rules, the petition is considered to be and presumed to be valid. That's part of the election code. It's part of 10-8. The burden of trying to keep it off the ballot is on the objectors if they file a valid objection, which in this case they have not. Now, this is a voting rights case, and that's why it's so important for this board to file the election law of Illinois. The Illinois Supreme Court, in a famous case, Coalition for Political Honesty versus State Board of Elections 2, that was in 1980, they said that when it comes to voting rights and initiative, the voting rights of the petition passers are intertwined with those who signed the petition. In this case, 3,871 people signed this petition. They're registered voters and residents of Evanston. They're 1,000 times more than the three objectors over here. But also, the court said, the rights are intertwined with all the voters of Evanston in this case. That's 49,933 registered voters. So this is a very important voting rights case, especially because it's the very first time that voters in Evanston have sought to use our Illinois Constitution. Section 11 of the Constitution in Article 7 does give voters the right to put a binding referendum on the ballot to deal with the structure and the behavior of their local government. And that's exactly what the people did here. It's the first time ever it's been tried in the history of Evanston, and it's a very important issue. With respect to the issue as far as the board is concerned, it has to follow due process. The petitioners followed the rules. The objectors over here did not follow the rules. Due process is about following the rules. And the integrity of the election process, the law, is extremely important here for the electoral board. You can't rewrite the law. You can't give a little extra help to the objectors. They have to specifically and affirmatively state their interest in the objection. They didn't do it. They're saying, well, it's good enough to be a registered voter. Well, our Illinois Supreme Court has said every word of the statutes, and especially here the election code, means something. It has a purpose. It's not superfluous. The General Assembly language that you must state the interest of the objector is not unnecessary or surplus language, as our friends across the way are trying to say. It can't be disregarded. It's a Supreme Court case that said, in several cases really, that every word of a statute must be considered and given meaning. And that's why the objectors, unfortunately for them, have failed to comply with the pleading requirements of Section 10-8 of the Election Code. And this board should refuse their invitation to ignore the code. You can't freelance here. There's no unique interpretation. Our Illinois appellate courts in the two cases that I have mentioned with respect to interpreting Section 10-8 have said again and again it's mandatory. It's not advisory. It's not directory. And it's interesting in their response, our friends, the objectors, did not even reply to a very central case in this matter, and that has to do with McQuillan versus Sullivan. It's a DuPage County election case. Now, Liz Sullivan was wanting to run as a candidate for an unpaid position. It was a trustee of the Lyle Library Board, and she filed her petitions, and along comes Mr. McQuillan. He wants to knock her name off the ballot. He doesn't want her to be a candidate. He says no to her. He filed an objection to her right to be on the ballot. This was a voting rights case over in DuPage County. Well, Liz Sullivan had the good judgment, I think, to get a legal counsel and to read the law. The lawyer for her laid out the case of Pookie versus Cook County Electoral Board, Daniel versus Daly, and pointed out that these were mandatory requirements, and the objector in her case, just like over here, did not state his interest. Did not state his interest. And the Electoral Board, following the law as enunciated by the appellate courts of Illinois, kicked out the objection, dismissed the objection. And Liz Sullivan was a candidate and got elected to the Lyle Library Board. So, you know, this whole issue that we're dealing with here in Evanston is very, very similar to what happened over in DuPage County. People file their petitions. They want to be on the ballot. They have a right to be on the ballot according to our Constitution and laws. And the other side wants to keep it off the ballot, and they have no legal claim to do that. I think it's important that this electoral board take a look at what happened in 2017, right here in Evanston. Two cases, one involving the mayor's candidates, another one involving candidates for city clerk. The objectors in that case did recite their interests. They properly followed the electoral board rules and the legislature or the election code rules, and they at least had their objection go forward, but they were overruled for other reasons. In fact,
if you could, we're at 8 minutes. If you could wrap it up quick, that would be great.
Okay. Well, I think in wrapping it up, in that very case, it was said in the objection to the mayor's candidacy, it's Welch versus Johnson. The case pointed out that ballot access is a substantial right in Illinois, not to be lightly denied. And that's why the mayor's candidate was on the ballot. The objection of Mr. Arndt was overruled. Same way with Ms. Green with respect to the candidacy of the clerk. And so rules are meant to be followed. You cannot give exceptions. It's too bad that they didn't do it the right way, but they didn't do it the right way. And so the election law of Illinois and the voting rights of the people who sign these petitions must be protected by this board. And this objection, it should be dismissed. It is a separate and equal and independent requirement that they state their interest. They didn't do it, and therefore they should be dismissed.
Okay, thank you. Okay, you now have the opportunity and the floor for to rebut that.
Thank you, Mr. Mayor. Thank you, Governor Quinn. Let's look at the petitioner's own words and council's own words about what this is about, what this petition and the referendum are about. It's a petition titled Evanston Voter Initiative. It proposes, in petitioner's own words, to change voting rights in Evanston. It's about the constitutional rights of Evanston voters. It's about letting voters decide. It's about, as Governor Quinn mentioned, it's about Evanston's 49,933 registered voters, which includes these 3 registered voters. As Governor Quinn says, this is dealing with the structure and behavior of our local government. It is a voting rights case. So let's flip that and ask ourselves, who in this world would have an interest in a case about the structure and behavior of Evanston local government, about voting rights in Evanston, about a change in voting rights in Evanston, about the constitutional rights of Evanston voters? The folks who have that interest are Evanston registered voters and Evanston residents. And we have clearly and succinctly stated that interest. The question of standing, although it's a different question and different requirement, there's nothing in the Illinois Election Code that suggests that the same facts can't establish both standing and a statement of interest. And in this case, given the nature of the petition and the nature of the referendum, by stating that we are Evanston voters and Evanston residents, we have satisfied all the requirements of the Illinois Election Code for objecting to this petition. In the McQuillan case, there's nothing in the record to explain to us what it was that was insufficient about that statement of interest and that nominating petition. And again, it doesn't require a strained construction of the petition, the case law in this case, or the Illinois Election Code to conclude that objectors have stated an interest in this case as Evanston voters and residents.
Thank you.
Well, contrary to what we just heard, in the McQuillan case in DuPage County, it was the opinion of and decision of the Electoral Board was the word interest was not mentioned at all by the objector to Liz Sullivan's candidacy. Mr. McQuillan didn't mention interest, just like our friends over here have failed to mention interest. The requirement to be a registered voter is part of another requirement of Section 10-8 of the Election Code. In order to get in the door, you must be a registered voter and resident of Evanston. That's a separate and independent requirement from stating your interest. Now, why do we require people to state their interest? Because, as we just heard, ballot access is a fundamental right, not to be lightly denied. So the idea of requiring objectors to state their interest, there's a purpose there. This is serious. They're trying to keep somebody, a candidate off the ballot or a referendum off the ballot. This is not a trivial matter. It involves the most fundamental part of our democracy, people's chance to vote. And so the objectors have a special duty here to comply with a clear requirement in the Election Code. The objector over in DuPage County failed to meet that duty. And that board, following 2 appellate court cases, said, I'm sorry, your case is dismissed. This board has to do the same thing here. These objectors did not in any way, there's nothing in their objection that says the word interest. They did not comply with that. They ignored it. They overlooked it. And this board should not allow the objectors to go forward if they don't follow the law. We followed the law. The petition passers did everything right. If they showed up at 5:05 after the clerk closes his office on the last day, they can't say, well, please give us a little extra time. No. That is not what the law says. We follow the law, and due process and equity and fairness require the objectors to do the same. They have not, and this board, if it's going to follow the election code and follow due process, should dismiss their objection.
Thank you. So now I'm going to open it up to the board for any questions. I'd just like to start. I guess I have two off the bat. One, does the law specifically say to anyone that's filing an objection that you need to use the word interest in it?
Well, the statute, which is the law, says a number of things. It says that the objector must give their name and residence address. They must state fully the nature of their objections. They must also state what relief is requested of the Electoral Board. But then it specifically says, and it's differentiated in the statute, it's separated by the words and it says, and shall state the interest of the objector. That's what the statute says.
So does an interest of an objector have to always use the word interest?
Well, with respect to the statute, the answer is yes. And in the case of this board, we have had recently, in 2017, 2 objectors who complied with this exact requirements of the statute. They objected to the mayor, to the clerk, and they stated right there, and we recited in our reply, that they came before the Electoral Board of Evanston back in 2017, and they recited their interest. They said the interest of the objector is as follows. That's what this board took it back then, and it would seem to me that the words mean something. As we said, the Illinois Supreme Court has been very, very careful at making sure that words in a statute are given meaning. They're idly. They're not easily disregarded, as our friends across the way are seeking to do. There's a specific requirement that's independent and separate from being a registered voter, because the statute also, another requirement, says you got to be a registered voter who lives in Evanston. So they met that requirement, but they can't use it for double duty. They can't say, well, we met it here, but we want to do it over here too. No, it's separate and distinct, and that didn't happen here, and that's why this is such a voting rights important matter. The petitioners follow the law, follow the rules. The objectors did not.
Okay.
If I may respond.
Oh, sure.
Mr. Mayor, the petitioner is wrong. There is nothing in the Illinois Election Code that requires that the word interest be used to state that interest. It simply requires a statement of interest. There's no requirement of specific wording. There's nothing to guide you on what amounts to or is sufficient for a statement of interest. And again, I'll say that the question of standing, although it is a different requirement, there's nothing in the Election Code that says that the same facts can't establish both standing and a statement of interest.
Okay, thank you. Did you consult or hire an election attorney to prepare your
We did not.
response? Okay. And then one final question. Do you, this is for the petitioners, do you think the objectors filed a frivolous claim?
I think the objection is meritless. I would not call it frivolous. I think it's without merit with respect to its substance. And that's very clear, as we point out in our brief, that they don't even recite the proper section of the Illinois Election Code that deals with referendums under Section 11 of Article 7 of the Illinois Constitution. The proper section is Section 28-7 of the Election Code. And our objectors over here don't even recite that. Now, this case, this sort of kind of matter did come up in the Daniel v. Daley case, where the court raised some questions about whether there was a good faith basis for the objection. And the very fact that our objectors over here have not even filed the right section of the Election Code, because our city council here in Evanston just the other day, recently, used that very section of the Constitution, Section 11 of Article 7, to put a binding referendum on the March 17th ballot. We bring it up in our reply. The resolution was passed by the City Council pursuant to their power under the Illinois Constitution, and they wanted to put that on the March 17th ballot. And we have the memo from the staff of the City Council, as well as the actual words of the resolution, which I have here. And the resolution of the City Council makes it very clear that the question on the ballot is a binding question. It's not advisory. And the City Council has that authority. We don't deny that. But if you read the Constitution, voters have the same authority as the City Council. The voters can petition something on that they want. And that's exactly what happens here. And so the idea from the other side that somehow this is not a binding referendum is refuted by the very words of the Constitution, by the words of the election code, and by every case that's dealt with this matter in the Illinois Constitution. We recited Clark versus...
Seems like we're getting ahead of ourselves, though. That's the next argument, right? I just want to, right now we're on the motion to dismiss these guys.
Well,
So I just
the
want
reason why it's relevant to the motion to dismiss is because in the Daniel case, they do bring up, when you're looking at objections, the presumption, number one, is the petition is valid. Number two, the burden is on the objectors. The objectors here they filed, frankly, an invalid objection. They're trying to rescue it here today with something that no court in Illinois has ever adopted. They don't use the word interest. They also ignore the fact that why would the General Assembly have a legal standing requiring for voter registration and residence and then say, well, that's okay for interest too. They put that interest in to underline to the objectors, this is serious business, taking away the voting rights of a candidate or people who file petitions and voters who want to vote on a referendum. That's serious. Unfortunately have not followed those rules.
Do you think that they filed an objection on bad faith?
The fact that they haven't properly recited the proper section of the election code that deals with any initiatives or resolutions for referendum that come pursuant to our Constitution, Article 7, Section 11, underlines that, this is not a serious matter. And that's what this should be. Okay. Voting rights matter. This is a voting rights case. It's one of the most important voting rights cases Evanston's ever seen. Okay. And, the good thing in reading, I had the honor of reading some of the Electoral Board decisions of these members here today and people before you. You read them over and over again, and you get the clear view that in Evanston you believe in ballot access. You believe in fairness and equity. That comes through in all of the decisions of this Electoral Board. That's what we're asking here. To be fair, we followed the rules, they didn't. Okay. To be fair, we did everything necessary to put a referendum on the ballot, just like the City Council did. And these folks over here want to keep it off the ballot, just like they wanted to keep Liz Sullivan off the ballot over in Lisle. Well, the Electoral Board of DuPage County didn't allow that to happen. They followed those two appellate court cases, which said the requirements are mandatory. And there was no interest whatsoever mentioned in the case involving Ms. Sullivan, McQuillan versus Sullivan, and just like here, there's no mention of interest.
Okay, I know yes. Others probably have questions and stuff, so I'm going to open it to other board members. I do. Rainey, do you want to go? All right, so Clerk Reed.
Yeah, so I have read the Daniel v. Daly case. I was just reviewing the Hookie case. And what I don't see there, and I haven't, what I don't see there is a direct link between the interest statement. What we did receive from our board counsel is a Fulton case from Chicago. And of course, the Chicago Electoral Board, these are, not binding to us, but they are persuasive. And in the Fulton case that we received from counsel, one of the issues there was that the objector did not fully state their interest. And the objector there, and the board there determined that the objector's interest could be inferred from their objection. And can you tell me how that is different than the McQuillan case?
Well,
or if there's a court case that specifically deals with...
The most recent case is Daniel v. Daley that deals with requirements in the election code, requirements.
Right.
And it made it clear that each requirement means something and must be met. And failure to meet any of those requirements, whether it's residence, whether it's failure to state nature of objection or whatever, makes the objection invalid. And I think this is important because the idea that giving extra rights to objectors is completely refuted by the statute. The very statute we're talking about begins with the words that the petition shall be deemed valid. It's not deemed invalid, and election objectors get free range to attack it. It's deemed valid. And so with respect to this matter, the appellate court cases, I think, are the ones that should be looked at. They're the ones where judges have decided. And the exact interest that came up in DuPage County, that case is on point here. The other side has not even mentioned it. They don't want to mention it for obvious reasons. They know that it's against them. And that's why here, you have to ask yourself, if you're required to state you're a registered voter, and that's all the interest the other side is saying in this matter, that they're a registered voter, it doesn't in any way meet the specific words, the affirmative statement of interest required in the statute.
Can you tell me once more the specifics of the McQuillan case? What did the objector fail to do there? They failed to specifically.
Well, I did bring the case today. I would like to present it to the board itself, yes, as well as the folks who are on the other side, and I will dig that out.
I guess for the objectors, do you have a response to the McQuillan case?
No, let's
to the
continue
assertions
this
made.
discussion first. Yeah.
Okay, is that it? No. Okay.
Yeah.
So this was McQuillan from 2017.
And you said that, oh, sorry. Thank you, sir.
Oh, thank you.
Do you think that residents of a community, whether it's Evanston or some other, should be able to object to any kind of petition without hiring a election attorney?
Well, they have perfect right to do so, pro se. They also have the right to hire somebody if they wish. That's not particularly the issue here.
That was just my question.
Yeah.
That's okay.
The issue here is, did the objectors follow the rules? And to delete out a specific affirmative statement of interest, as the objectors are seeking to do,
right,
is not playing fair.
Right. You're arguing, though, that the rules are clear in your mind that they needed to use the word interest. They didn't use the word interest. Therefore, they should be dismissed.
I am arguing that because the Illinois Supreme Court has said that every word in a statute means something. Mm-hmm. Nothing superfluous. There's no surplus language. And so the reason that the General Assembly put this clause in to the election objection statute is to underline how serious the matter is. trying to keep somebody off the ballot as a candidate, like Ms. Sullivan over in DuPage, or trying to keep a referendum off the ballot here in Evanston, that's serious. And they underline their, frankly, lack of seriousness by not reciting their interest.
Okay.
Other objections in this community to candidates, firsthand you know, did properly recite the interest. Not here,
Okay.
not at all.
Any other questions? Alderman Rainey.
Governor Quinn, do you know of any electoral boards that did not dismiss a case because the word interest was not used in a petition for a referendum?
Do I know of any electoral board
That did not
dismiss? No, I do not. I know of an electoral board that followed the clear direction of two appellate courts. That's the one in DuPage County. That's the one that is, I think, relevant here. You get one bite at the apple. Unfortunately, the other side wants two bites of the apple. And this isn't fair.
The reason I asked the question is because we hired an attorney to represent us. And the information that we received is that in their experience, electoral boards do not often grant motions to dismiss based on an objector's alleged failure to use that word.
But we have a clear case in
You have a
DuPage County.
case. You have a case, yeah.
Yeah. And we also have two Illinois appellate cases where appellate judges, said this is not something that you kind of decide to do if you want or if you don't want. They said, no, it's mandatory. And it's serious because election rights and voting rights
I heard you.
are at stake here.
Right.
And
But the objector is claiming that they have stated that interest.
well, if you allow them to get away with that, it means that that whole section of state your interest of the objector is unnecessary. Because the moment you say you're a registered voter in order to have standing, which is another requirement of the election code, once you say that, there's no need to even worry about state your interest. That's what they're trying to rescue their matter on. Now, I would say, if the objectors don't like the referendum question.
I was just going to ask you, why do you think they filed?
I think they
The objection.
probably, I would guess, do not support the referendum. They're entitled to that.
Why?
That's why I think it's healthy for this city, which has a long tradition of ballot access, to have a robust campaign. There are going to be people voting yes, some people will say vote no. But that's what elections are about. That's what democracy is about. That's what you ran for office yourselves. There were candidates perhaps ran against you. But there's a contest. And I would, in good faith, ask the objectors to withdraw their objection, not put this board through the problems here, but instead have a good campaign and let the voters on March 17th vote on this issue, just like they're voting on the nonpartisan election for mayor. The city council put it on. They have a perfect right to do it. There'll be a good campaign about it. Same way here.
Okay, thank you. Jane.
Yeah, thank you. In just a quick glance at the McQuillan case, all that the board concluded in that case was that the objector had failed to state an interest without shedding any light upon. We don't have a copy of the objection. We don't know what was missing from that objection. And again, I will agree that due process should govern here, that fairness should govern here, but also common sense. And if the petition itself implicates voting rights, the structure and behavior of local government, that those who have an interest are the voters and residents of Evanston. And we've laid that out clearly and succinctly in the first sentence of our objection, knowing full well exactly what the Illinois Election Code required of us to state the objection. And it sounds to me as if the Fulton case, which I haven't read it, that our interest can be inferred. If you need to infer it from a clear and concise statement of interest, please do. It allows you to use common sense and logic to reach the conclusion that the motion should be denied.
In responding to our friends across the way, we took a look at the Fulton case here, and what happened there is the objector failed to recite their interest. They had an incomplete sentence dealing with interest, and that's what the court meant by meaning can be inferred. There was an incomplete sentence, and that's why they were able to get away with it. Not here. There's no interest or sentence at all. There's no word at all of interest. And so in Fulton, they tried to state an interest. They had an incomplete sentence, and the court inferred it from that. But here, they're just basically saying to this board, ignore that one. We made a mistake. They did. And we want to keep going. But they can't do that. That isn't what voting rights are about. Voting rights are presuming the petition is valid. That's what the statute says. And the burden is on the objector to follow the rules. They didn't. And now they have to suffer the consequences. And let's have a referendum. I think that's what my clients want. They understand that there'll be a robust discussion and a good campaign, the way Evanston always does it. And why not?
So, City Attorney, do you have anything that you've done a lot of legal research here and everything else, anything that you have, questions or comments that you want, and then I just want us to get into either a discussion or take a vote on this matter?
Sure. Counsel, I have a couple questions for you about the cases to give you an opportunity to respond on the record. You cited the McQuillan case, and we talked about the Fulton case, and I think you'll agree those are persuasive authority. You mentioned the binding authority from the appellate court cases that you mentioned. And the Pookie case dealt with a incomplete address,
Right.
a different requirement of 10.8, not the failure to state an interest, correct?
That is correct. The holding, however, said all requirements are mandatory.
Sure, but that case also said that the address in that case was incomplete, and they couldn't infer the address by looking at the four corners of the objection. In this case, couldn't you infer the interest of the objectors by looking at the four corners of the petition?
No, I don't think you can, because the word interest, stating your interest, is not at all mentioned. You know, if you can just say resident and registered voters, and from that you infer an interest, that defies the actual words of the statute. Our Supreme Court, again, has said words mean something. They have a purpose. You can't just delete them out because it's convenient. The fact is, they have to state an interest, and they did not do so.
Fair enough.
They never used the word interest whatsoever in their entire objection. So you can't infer something from anything incomplete because they don't have a beginning to it.
Thank you. Do you care to comment?
Nothing in addition to what I've already said.
Fair enough. And then Daniel B. Daly, the other appellate case you mentioned, you'll agree that had to do with the failure to fully state the nature of the objection, not the failure to state interest, correct?
Right. Those cases did not deal on point with the issue of stating your interest. They did, however, both holdings said the mandatory requirements of Section 10-8 are not advisory or directory, they are mandatory, and they must be enforced. And that's what the Electoral Board over in DuPage County used to decide a case where an objector in Lyle, trying to keep a woman off the Lyle Library Board ballot, they said, wait a minute now, there's no interest at all here. They haven't mentioned it at all in their objection. So, sorry, Mr. McQuillan, your objection is dismissed. Just like here, they didn't mention anything about interest. It can't be inferred from anything. You can't use registered voter to infer it because that's required to get standing, a different requirement. A separate and independent requirement is you must state your interest. And here, that didn't happen, and it's a voting rights matter of great import, a ballot access issue, and instead of prolonging this, I think the objectors ought to decide to withdraw their objection and let the campaign begin.
But Daniel V. Daly didn't deal with the failure to state of interest. Pookie said you can infer an address, and Fulton said you can infer an interest.
From an
Isn't
incomplete sentence.
isn't that more on point than the McQuillan case?
I don't think so at all. Matter of fact, Pookie was very clear that the objection was dismissed because there was no inferring anything.
You couldn't in that case.
Yeah, but what they said is they didn't meet the requirement of the address in that case. Daniel versus Staley, the requirements weren't met. The notion of inferring from an incomplete sentence is what Fulton's about. There's no incomplete sentence here. There's no word at all of interest. They failed to do it. They overlooked it. That's the way it goes. They missed the boat. And our folks, if we had that same kind of inferring approach, we could show up at the county clerk's office and instead of the city clerk's office and file our petitions at 5 minutes after the deadline, and we'd say, well, come on, can't you infer from our intention? No. The rules are the rules. And they're important rules because ballot access is a fundamental right in a democracy. It's not something to be trivial. It isn't to be trivialized. It's something that matters. And the folks here who filed the petitions, filed the rules, the other side didn't, and this board should stand up for that right. You can't rewrite the election code to please them.
Isn't it ironic that, and this is just a hypothetical, somebody could come in, a group could come in from outside of Evanston, push for a certain referendum, they don't live in Evanston, get the signatures for that referendum, some residents in Evanston could object to it, file an objection on their own without, because they couldn't afford it or for whatever reason, consulting an election attorney, and have that objection dismissed in your case and what you're arguing because they didn't use the word interest. Even though they said, let's just use reparations as an example. We just, in Evanston, created a reparations fund. I get emails, right? You know this as a former governor. You get emails from lots of people outside of your area who have said what a bad idea this is. So a group comes in, puts together a whole referendum that says, should Evanston terminate its reparations fund? And
But
they go out.
excuse me, what has this got to do with?
I'm just using this as an
If I may-
example.
if I may-
I'm just
if-
using this as an example, Alderman, that if, again, people in Evanston, this outside group
Well,
comes in and people in Evanston object to it,
Excuse me, can we,
order, please.
if I may interject, I think excuse me, folks, excuse me.
I move that I be allowed to have a conference with our attorney.
If we can hold the recess for 1 second, I
Yeah.
will second you. I will second
Okay.
it, but just give 1 second. The difference there is, and again, I do feel like this isn't necessarily where the board should be, but just to answer that question is, at the end of the day, at least 2,700 registered voters of Evanston would have to sign that anti-reparations referendum, and then the Evanston voters would get to vote on that. So even if an outside group did come in, ultimately Evanston voters are the ones who determine if it gets on our ballot and if they support it or not. And to further answer your question, we're still here in the case, but to say that, the weight of, that's all I have to say for that. I won't go any further. Yes.
Okay, does anyone want to move a motion?
Motion to recess for 5 minutes.
Okay, so
Second.
all in favor? There's a second? Okay, so we're going to recess for 5 minutes, and then we'll come back. Okay, thank you, everybody. We're going to go ahead. Is there a motion to continue? Resume? A second? Second? All in favor? Aye. Alderman Rainey, you're good for resuming this meeting, I presume. Okay, all right. In regards to this motion to dismiss from the petitioners, do we have a motion up here at the table?
I have one more question, if I may ask.
All right, we'll ask one more question, and then if we're done with questions, we'll go ahead.
Yes. Would you categorize the McQuillan case as maybe do you think that's the norm, the determination that was made in the McQuillan case, or would you see that as maybe kind of outside of the norm or an oddball case? Or a unique case, I should say.
I think the McQuillan case in DuPage County follows the exact words enunciated by two appellate courts in this state. They point out the word interest was not mentioned at all by the objector to Ms. Sullivan, Mr. McQuillan, and they followed the law. They followed the election code. So it's not outside the norm. It's exactly what electoral boards have to do. Objectors don't have their objections presumed valid just by filing them. They have to comply with the law. And in this case, if all you have to do is say I'm a registered voter to satisfy the interest provisions of the electoral code, then those words don't mean anything at all. To state your interest is not required, really, because you've said I'm a registered voter. That's enough. They don't even say anything about interest in this case, nor did they in McQuillan, and McQuillan did the right thing.
Thank you.
Okay, thank you. Is there a motion that someone would like to put forward? Alderman Rady?
Yes, I move to deny the motion to dismiss and sustain paragraphs 1 and 2 of the objectors' petition.
Well, we have
All
not
right,
gotten to the...
So you're getting a little ahead of yourself. So right now, we're just on the motion to dismiss. So if you want to move that one, and then we're going to have a hearing.
I move to deny the motion to dismiss.
Is there a second? Aye, I'm a second to that motion. So we'll do all in favor of dismissing the motion to or denying.
Get a roll call.
Yeah.
Okay, roll call. Okay, Clerk Reed?
No.
Alderman Rainey?
Aye.
Mayor Haggerty is an aye. All right, so the motion to dismiss is denied on a 2-to-1 vote. Okay, we're now going to move to the next item on the agenda, which will be the Objectors Petition. Okay. And the motion.
I move to sustain paragraph 1 of the.
Oh, excuse me for 1 second. I'm sorry, Alderman. Okay. Yeah. So I'm going to ask. Yeah. So I'm going to ask the city attorney now just to take us through the process-wise, because both parties are going to get 10 minutes, up to 10 minutes if you need it, now to argue the merits of why you're asking for an objection and that this be removed from the ballot, and why you disagree with that. So, city attorney.
Thank you, Mayor. This procedure is familiar to you from the motion to dismiss, except for this time it's the objector's burden. Objectors go first, proponents, and then objectors. It's 10 minutes aside. If you want to reserve time for rebuttal, or if you're going to grant additional time on rebuttal, that's the discretion of the board. After presentation of your case in chief, after you present your arguments, questions, we might recess to consult with counsel. There will be a motion at the conclusion of the argument. At least we expect one. So, and hopefully we'll resolve this tonight.
Okay. So before we get to the objectors' arguments, for the board up here, our rules allow for 10 minutes. I'd suggest that each party be given the full 10 minutes, and in those 10 minutes arguing all of your different objections. So if you have 2 objections and you're rebutting to 2, you got a total of 10 minutes. Okay.
To the mayor's point, when the board takes final action, there are 2 paragraphs of the objector's petition. My advice is to take action on them separately to make a clean record.
Okay, but the arguments themselves that they're doing right now can be done together,
Exactly.
and then we'll move separately on each of those objections. Okay. All right, so then I'm going to turn the floor over.
I do think there may be some merit in allowing 10 minutes for each of the two paragraphs. I do think it, this is an important matter, and I do think there, we could get into the meat of it with each one of them individually.
Do you need 20 minutes? No.
All right.
They don't need it.
All right. Well,
All right, we'll stick with 10 minutes for each side, and then you'll have the opportunity to do a rebuttal as we did previously. All right, so I'm going to turn it over now to the objectors.
Great. Thank you, Mr. Mayor. First, we want to ask, and I'm hoping Governor Quinn and the petitioner will join us in this, is to ensure that that none of the Electoral Board have been involved publicly and previously in opposing or supporting the petition or this objection that would somehow undermine or impede a fair hearing on the objection or the petition, its merits, as it's hard to be both a public advocate for or against the petition or the objection and deliberate its merits. This is not a formal request to recuse, but I would simply like you to consider whether or not any previous public activity with regard to the petition or the objection might impede a fair hearing. So, getting to our objection, please.
Before you do that, is there anybody up here concerned about that?
I did invite Governor Quinn to speak about the initiative process a year ago after meeting at the Chicago Board of Elections, but I did not, I was not involved in the actual petition process, so I didn't submit any petition signatures. All
right, thank you.
Okay.
For the record. So we agree that this is an important issue, important question of public policy. We do not debate that at all. We're not challenging the gathering of the petition signatures, which was, by all accounts, an extraordinary effort, or we're not challenging the validity of those signatures. We're not addressing the referendum process proposed by the petition. Our objection is based on the nature of the petition itself and the wording of the referendum question. The evidence in this is the only thing that you really need to see is the petition. A copy was attached to our objection. We offered two grounds to reject the petition and not place it on the ballot on March 17th. And that first is that state law, both the Illinois Constitution, which leads us to the Illinois election law, does not permit a binding referendum on a local question of public policy. The petition reads, and it's atop the petition, if approved, the question shall take effect immediately upon referendum approval of the question. Petitioner's filings concede that this is a binding referendum. The petition does not offer an advisory referendum. The Illinois Constitution permits referenda by petition of the electors, but also requires compliance with applicable state law. The Constitution says, proposals for actions which are authorized by this article or by law and which require approval by referendum may be initiated and submitted to the electors by resolution of the governing board of a unit of local government, such as a city council, or by petition of electors in the manner provided by law. The manner provided by law in this case is what the Illinois Election Code clearly prescribes. The Illinois Election Code governs the submission of all public questions via referendum and does not permit binding referenda on local questions of public policy, such as that presented by the petition. The Election Code requires that local questions of public policy shall be advisory public questions, and voting on such questions shall have no legal effect. This petition explicitly intends to have a specific, binding, and immediate legal effect, the institution of a new process for enacting local law. This is sufficient grounds to deny the petition. Our second objection, our second grounds to deny the petition, is that the referendum question is confusing. It is not easily understood and will mislead voters. It is 383 words long. It has long compound sentences, some with more than 50 and 60 words. Those sentences themselves are often longer than entire referenda questions. It contains multiple parts which are not self-executing, that leaves gaps to be filled in by amendments to the city code of Evanston. It has inconsistent and confusing terminology and wording, referring to proposals in ordinance form, official summaries of proposed ordinance, official petition summary, proposed ordinance, official summary. The third sentence of the first paragraph is especially confusing. It doesn't clarify who introduces the petition to be filed with the city clerk and appears to use permissive language as to whether 8% petition signatures are required or optional. Can that petition process be circumvented? The second paragraph refers to the next regularly scheduled election held in all precincts of the city and another unspecified election. Are they the same or are they different? In a lot of ways, the language and wording of this petition disenfranchises voters rather than empowering them. Can a reasonable person make sense of this referendum question without requiring a flow chart or a postgraduate reading level? I invite you to plug the referendum question into a readability program, and we'll find that it is very difficult to read and registers at an average 20th grade level, which is postgraduate. Does the question explain the referendum process in a way that an average voter can understand it when seeing it for the first time in the voting booth? Surely the proposal, this petition, can be presented in plain and accurate language that respects voters' intelligence and clearly informs them about the choice that they're making. You have the responsibility to ensure that people can easily understand the proposal that they're being asked to vote on. This is a binding question that would require the City Council to amend the City Code to implement it. It cannot be self-executing. It must require amendments to our City Code to make this happen. And for that reason, again, it is confusing, it's compound, not easily understood, and will mislead voters. Thank you.
Thank you, Ms. Grover. Okay, we're going to turn to the petitioners now to respond.
Well,
And again, you have 10 minutes.
the Illinois Constitution was adopted in 1970. It was the first time in history of Illinois that a local government article was actually included in the Constitution. Prior to 1970, everything was controlled by Springfield. The City Council of Chicago wanted to sell peanuts on Navy Pier. They had to go down to Springfield and get a state law passed. There was a lot of unhappiness about that, not only in Chicago, but here in Evanston and across Illinois, that people in their local communities wanted home rule. They wanted local control. And that was one of the key reasons the Constitutional Convention was called. That was one of the main reasons the Constitution was drafted by the delegates, submitted to the voters, and approved, to give every community that wanted it to have home rule. And Evanston has home rule. And under the provisions of the election code, of the Constitution, they put in to make sure that everything was carried out the way the voters wanted in 1970. The voters ratified the Constitution. They put in an initiative provision for the first time in the local government article. And that's Section 11. And matter of fact, the CON delegates said the dominant theme of the local government article is flexibility of form, of structure, of powers, function, territory. Many decisions authorized by this article depend upon a referendum. The opportunities which the article offers will not be fully realized if it does not assure the people and their governmental representatives that the decision-making process can be invoked and when necessary. And then they follow up and finish up with saying the initiative is intended as a form of insurance to guarantee that the flexibility and adaptability offered by the local government article will not be foreclosed by unduly limited opportunities to invoke its provisions. That's from the Record of Proceedings, Part 1, Committee Proposals in 1970 of the Constitutional Convention. And that was what the voters understood when they adopted this initiative. Now, it's very clear from the words of the Constitution that units of local government, like the Evanston City Council, have the authority to put a local referendum on the ballot that is binding. As we mentioned a little bit ago, there was a resolution passed by the Evanston City Council. They had a memo beforehand that said, you know, if you do this referendum on nonpartisan elections, it's binding. It's binding. And you have the authority to do it under the Article 7, Section 11, part of the Constitution. And then when they actually voted on the resolution, it says right here in Section 3, said referendum shall be a binding referendum pursuant to Article 7 of the Illinois Constitution and the Illinois Election Code. Well, if you read the Illinois Election Code, here it is, 28-7. And it says right here that in order to have any action carried out with respect to a local government like Evanston, subject to a referendum like we're talking about here, any such public question shall be initiated in accordance with this section. The objectors don't bring up 28-7 at all. They don't even know about it. And here it is, right there in the Constitution, the statutes laying out the constitutional right, and it says that any such public question may be initiated by a government body, as we saw here in Evanston, but also by the filing of a petition by the voters. And they have 8% of total votes cast, requiring the signatures and where to file it and when to file it and so on. Now, this is no doubt about it. The statutes of Illinois and the Constitution are crystal clear that this is a binding referendum. Matter of fact, if you read the Constitution itself, it says if the majority of voters vote in favor of the Evanston City Council resolution, their referendum, well, then that's the law of Evanston. Same way here. It's a binding question. Now, the objectors in no way, shape, or form have read any cases regarding this statute, or this section of the Constitution. The leading case is Clark versus Arlington Heights. It was, the case came down in 1974. It was right after the Constitution got adopted. The voters, well, the city council up in Arlington Heights, they wanted to have an appointed city clerk, not elected. They wanted to increase the size of their council from 6 to 8. The state statutes before 1970 wouldn't let them do it. But the city council wanted this change in their government. And they put a binding referendum on the ballot. The voters voted for it. Mr. Clark said, oh, no, we can't do that. That's not a binding referendum. He went to the Supreme Court, and the Supreme Court said very clearly, yes, you can. That's what we adopted, the voters adopted in 1970. And in another case, more recently, 2016, voters over in Broadview wanted to have term limits on their mayor in that town. They filed a petition. They had a referendum. There was an objector there, too, and went to court, went all the way to the Supreme Court. And the Supreme Court said this is a constitutionally valid referendum. It's binding. Its ballot language is not ambiguous. It's not vague. Johnson v. Ames is the case. We have it cited in our original brief there to motion to dismiss. Another case, City of Moline Flowers versus City of Moline. That was back in 1993. There, the city council decided, well, let's modify the powers and duties of the mayor, the city administrator, the city council. And they did. They put it on the ballot. It passed. Mr. Flowers said he didn't like it. Went to the appellate court, and the appellate court said Clark controls this case. The words of the Constitution control the case, and 28-7 of the Election Code controls this case. And it's all designed to give greater autonomy to voters in their local community in determining their government affairs and tailoring their city government to their own special needs. Now, the Flowers Court also dealt with the issue that alleged here by the objectors about confusion. The court said the landmark case is Hugousian versus RTA. That's the case that controls here. And the court said, the Supreme Court, said that a sufficient ballot need only present a proposition in the manner where the voter has a clear opportunity to express his or her choice, yes or no. That's what Hugousian stands for, and all kinds of cases after it, including Flowers versus City of Moline, which controls this case. And so here we have 3,871 voters here in Evanston. They weren't confused when they signed the petition. There was no confusion. They signed the petition. So the very idea of saying it was confusing, it's insulting to the petition passers and the signers. They signed the petition. It's a clear question on the ballot. Voters will have a chance to analyze it. That's all the petitioners here are trying to do, give voters a choice. That's what Huguzian says. So the idea of confusion, that is a red herring used by political opponents of the question to try and keep it off the ballot. And this board should not in any way accept the invitation of the objectors to do that. They have a right to be against the referendum. They don't have a right to keep it off the ballot. And then on the whole subject of initiative and such, it turns out Arlington Heights, the very place where Clark took place, the Clark case, well, they decided in 1980 they wanted recall in Arlington Heights. And they put that on the ballot, and it passed, and it's the law of Arlington Heights. They have recall for their local officials. Then Arlington Heights said, well, we'd like to also have initiative here in Arlington Heights. And in 1981, in the April election of that year, the city council, or the village board there, put a referendum on the ballot. We have it right here, the Arlington Heights Initiative. It's part of their code today. It's part of the municipal code. It's been around for, well, 39 years, almost 4 decades. Arlington Heights is doing exactly, not exactly, but very similar to what's being tried here in Evanston. So the objectors, I don't see how this board can take them seriously when they don't even recite 28-7 of the election code, which, just to read it one more time, it's very important, I think, to keep this in mind, that this particular section of the election code makes it crystal clear that 28-7 supersedes any other part of the election code. If you read 28-7, it says, this is the way you carry out a referendum that's authorized by the local government article of the Illinois Constitution, and it supersedes anything else. So our friends over here are bringing up different sections of the election code. They're superseded by Article 28-7 of the Illinois Election Code. And so for this board to allow them to attack a duly petition for a referendum is just plain wrong.
Thank you. Do you have a response?
Yes, thank you. The controlling provision of the Illinois Election Code is 28.6, which requires that local questions of public policy be advisory referenda. 28.7 does not supersede another provision of the same Illinois Election Code. Rather, it applies to different circumstances for referenda questions.
Just to deal with that.
Is there? I just want to make sure, process-wise, we're following everything okay.
Right. The board's rules say no sir rebuttal, so this is up to you guys.
Okay, so we can ask questions and stuff like that. So, I'll go ahead, Clerk Reed. Did you want to say?
I don't know if maybe we should make a motion to allow the sir rebuttal.
Up to you.
It's up to, I make a motion to allow the rebuttal. I think it's fair.
I'm fine to second that motion. Hear the rebuttal.
All in favor? Aye.
Okay. Aye.
Okay, going forward. Just to read 28-7 to make sure that the law is clear. It says this section is intended to provide a method of submission to referendum in all cases of proposals for action which are authorized by Article 7 of the Constitution. And supersedes, that's the word of the statute, any conflicting statutory provisions. Now, the other side is saying 28-6 or whatever other section they're trying to recite somehow controls here. Well, if that's the case, then how did the City Council put a referendum on the ballot for March 17th? They followed 28-7, which says it's a binding referendum. And that's what the memo of the staff of the Evanston government pointed out to the alderman and the mayor in considering this measure. These are binding referendums. That's crystal clear from the cases, from the words of the statute, of the words of the Constitution. All kinds of referendums have been held under this particular initiative provision of the Constitution since 1970. And there's never been a question that they are binding. this is really a first, that somehow you're trying to say that when voters exercise their rights under the initiative provision of the Constitution, it's not binding, it's advisory. The delegates didn't say that. The voters didn't say that. Arlington Heights, in the leading case, made it very clear that this is a binding referendum. And our Supreme Court actually expressed impatience in Johnson v. Ames with folks who were saying, well, it's confusing, and trying to stop that referendum over there in Broadview. The court said, it's crystal clear. This is valid. This is the right of the people. That's what the people adopted in 1970. You can't take that away from them. Now, our friends on the other side, okay, they aren't for this referendum. Good. Go out and campaign against it. That's the heart of democracy. But the idea that they can somehow call off a referendum that's been signed by 3,871 registered voters here in Evanston, 3 objectors over there, no, that would be a gross violation of ballot access and voting rights, which this community, in case after case before this board, has said is a fundamental precept of Evanston. And in one case, the mayor might know, it was held in Art v. Haggerty, that they recited a Supreme Court case that access to the ballot is a substantial fundamental right that is not lightly to be denied. And that's what they're trying to do over here, deny the right of ballot access on specious grounds. They didn't even recite the right part of the election code in their count 1, and in count 2 with the referendum question, it's complying exactly with Lipinski, with Leck, with Aguzian, with Flowers versus City of Moline. All those cases require the petitioners to lay out a question where people can make a choice. That's what's happening here. And this is a very important matter for people of Evanston to have a chance to vote on.
Thank you. Okay, I'm going to open it up to questions or comments.
Yeah.
Clerk Reed?
I do. So I do have one question, I guess, to start off with our board counsel. In the memo that we received, there's only a focus on 6F in that memo. And the memo did not go into 28-7, which the proponents are saying is the governing.
Sure.
Yeah. Can you maybe?
Sure. That is a question I have for the proponents. To the proponent's argument, 28. You're in your pleadings. You're relying on 28-7, and of all the headings of the laws, the constitutional provisions cited in the petition heading, only one of them authorizes a public question, and that is 6F. That proposes an alteration to a form of government provided by law. And I guess one of the major questions that I had reviewing the law in support of the petition was what law authorizes this alteration of the form of government?
Well, I would advise you to look at Flowers v. City of Moline, which deals exactly with that subject.
Right. And in Flowers versus City of Moline, the city adopted an ordinance providing the alteration of the form of government. And the court said in Flowers versus City of Moline that the ordinance that was adopted first, followed by a confirming referendum, was the correct procedure to follow.
If the voters had petitioned that very same question on the ballot, they would have had the same rights to have it on the ballot. There's no difference between a resolution by the city council and a voter initiative petition on that very subject. And if you read 6F, a home rule municipality like Evanston shall have the power to provide for its officers their manner of selection and terms of office.
Is that what we're doing, or is this a form of government?
We lay it out in the Constitution that they have the power, the home rule has the power, subject to referendum, to adopt, alter, or repeal a form of government And they also have the power to provide for their officers.
No, but you stop short there, though, and that's what the Flowers case hit on, is that it's a form of government provided by law. They were looking for a source of law in order to authorize this alteration of the form of government. Where is it?
Well, number one, to point out, this is not part of the objection, what you're bringing up.
And that is, if I may, for the record.
You cannot amend the objection. That's what you're trying to do here.
No, if you look at the objection, they say that if you read the Objectors Petition, it says
that. So if I may,
let the attorney.
The petition.
That's what they do.
Excuse me, counsel. The petition referendum question present a binding referendum that is now not allowed by law. That's in the Objectors Petition, and so we have to ask, how is it allowed by law? And to their point, they are confused whether it's advisory or binding based on what's on the Excuse me, counsel. It is. There's a question about whether it's advisory or binding, and that's probably why they cited 28.6 in paragraph 1 of their Objectors Petition. The petition heading cites all kinds of constitutional provisions that suggest that this is advisory. Article 1, Section 5, for example, the right of the people to make their opinions known, suggests an advisory referendum.
No,
I'll let you respond.
It does not. You have a fundamental right under Article 1, which is the petition clause of our Bill of Rights, to petition. The very fact that the petitioners recite that doesn't mean that they are not reciting specifically Article 7, Section 11, which that's cited in the petition. It's crystal clear. Once you say you're going pursuant to Section 11 of the Constitution, of Article 7, it's got to be binding. There's nothing else. The words of the Article 7, Section 11, make it clear that it says right here that questions submitted to referendum shall be adopted if approved. That means they're law. They're binding. They're not advisory. So it's very clear that that's what the petitioners were seeking to do.
But you were asking me about Article 28. In Article 28, the petition heading doesn't say what section of Article 28. It cites the whole article.
At seek, yes. But the very fact, if you invoke Section 11 of Article 7 of the Constitution, according to the statute, which is 28-7 of the Illinois Election Code, it is the controlling section of the Election Code for these kinds of binding referendums. The City Council recited that themselves. And this very statute that I just recited says it supersedes anything else in the Election Code. It is the sole way, statutory way, you submit a question. The other side did not in any way recite 28-7, which is the controlling provision. And matter of fact, when Arlington Heights put their question on the ballot for initiative pursuant to the Article 7, Section 11, and 28-7 of the Election Code, that's exactly how they did it. And that's what we're doing here. And so, and it must be pointed out that this objection does not include anything about that at all.
If I may, I'm a board member, sir.
But let's let our attorney finish, and then I'll go to you, Clark Reed.
Thank you. You mentioned Arlington Heights and Clark versus Arlington Heights. Again, it was a ordinance with a confirming referendum, and you mentioned that the initiative procedure in Arlington Heights was also approved by ordinance with a confirming referendum.
No. It was put on the ballot by ordinance.
Okay, so it's still an action by an exercise of the power of the home rule unit, which is what the Constitution says.
It's identical. The voters have the identical power that a unit of government has to put questions on the ballot under Section 11 of Article 7. There's no more greater power for a unit of government in its city council than it is for the voters. That's why I read earlier what the Constitutional Convention said. They were concerned about that very subject you're bringing up. And the Constitutional Convention said, well, we have an initiative here, not just the city council putting referendums on the ballot. The initiative is intended as a form of insurance to guarantee that the flexibility that the delegates wanted would not be foreclosed by unduly limited opportunities. So the constitutional debates make it clear that voters have the identical power of a council to put a referendum on the ballot. There's no more greater power that a home rule unit has than their own voters. We have the same authority as what Evanston just did with the city council resolution for a referendum on the nonpartisan election. That's fine. They had the right to do it, and it's binding. The idea that somehow a voter start to invoke that provision and it's not binding, that's what the objectors are saying, they're wrong, because it's the same power pursuant to Article 7 and Section 11 and 28-7 of the Election Code.
Right, but if we're going to follow your argument, that's
Point of
under
order.
20.
I do believe point of order.
I can let him
it should
respond,
be
Clerk Reed, and
recognized.
then
My
you'll
point
have
of
the
order should be
opportunity.
My point of order should be recognized.
I would like, you could just respond, and then we'll go to Clerk Reed.
My point of order should be recognized. Chair's call. And the point of order is, I'm slightly uncomfortable with the nature of this. I do feel that our board attorney, it's almost as if we hired an attorney for the objectors, and I do feel that the board attorney should pull back a little bit and represent both sides fairly.
I'm listening at all sides here in this argument.
Yeah, he's
So.
leaning to us.
No, I'm just saying. Okay, are there questions up here from members? I'm going to have our attorney.
Can I respond to that?
You can, sure.
To the clerk's point, I represent the board, and the members of the board might disagree with my opinion of the law, and the proponents and I might disagree about the law that applies here. I'm trying, and by asking these questions, I'm actually helping the proponent. I want to hear your responses to these questions on the record, because there are concerns that I have. And so
Your concerns are not included in their objection. You're trying to amend their objection.
I disagree, counsel. It says that the
Order, please. Order.
it says that the referendum is not allowed by law, and I'm asking you to where an article, how is this alteration of the form of government provided by law under Article 7.6F?
Well, Flowers v. City of Moline makes it clear that you can do what the petitioners in the instant case are trying to do. It's a very clear case, and it deals also with this confusion argument of the other side. It recites Huguzian. Now, Flowers was decided in 1993. Prior to that, in 1981, without objection, the people of Arlington Heights adopted their version of initiative. They did a recall and initiative pursuant to this very statute, as well as the section of the Constitution. No one has ever challenged what they did in Arlington Heights. They said they had the right to do it. They're a home rule unit just like Evanston. They adopted it. It's been the law for almost 4 decades. There's nothing in the law that prevents the people from doing this. They have a right to alter their government. They have a right to provide for their officers. Their officers have powers and duties. Those words were used in the Flowers case. That they were modifying the powers and duties of the city council, of the city administrator, and of the mayor. They use those words, modifying the powers and duties. That's what we're doing here, modifying the powers and duties, and also giving people the right to bring issues before their city council. And that is another way that the Constitutional Convention delegates wanted local government to work. They said this is a laboratory of democracy now that we've adopted this new Constitution. We don't want every city to be the same. Folks in local cities can decide for themselves how they want their local government organized, but they got to do it by referendum. And so we're going to have a referendum. Should we have nonpartisan elections? And candidates for various offices here in Evanston, and voters vote for it on March 17th, so be it. The city council put that one on the ballot. But the voters could have put it on the ballot. Matter of fact, your memo here, the Evanston memo from Hugh DeBose, Assistant City Council, made it clear that that very referendum could have been put on by petition as opposed by resolution of the city council. But it was put on by resolution of the city council. Now, you can't gang up on the voters when they, for the first time in the history of Evanston, in 50 years under this Constitution, finally decide that they want to have a way to reform their government the way they see fit, and say, well, the city council can do it, but you folks can't. And then you let the objectors over here show up with an objection that doesn't even bring up the proper section of the election code that controls this part of the Constitution. They don't bring anything up. You can't make an argument for them. They can't amend their objection. They bring up in their objection 28-9. That doesn't apply to us. That's why this particular count should be thrown out right away. And as far as the confusing ballot language, I think the courts have made it clear they're very impatient with political opponents to a referendum showing up in court trying to knock it off the ballot saying confusing. Courts don't buy that in Illinois, and thankfully they don't. Let the voters decide the question because they're given a clear choice.
Okay, so I have a couple questions here. The Arlington case, so did the voters of Arlington put together that referendum and put it on the ballot, or did it pass through the Arlington City Council and then get on the ballot?
The city council passed a resolution putting it on the 1981 ballot in April. Okay. The council passed it.
The council did, and then it went on. So that's very similar to what's happening with this March referendum in terms of changing the voting here. The city council passed it and put it on. Okay.
But as we've said repeatedly, if voters had petitioned it in Arlington Heights, it should have been on the ballot the same way. Initiative petition has the same right as council resolution to put referendums on the ballot in this area. I have the actual.
So are there a bunch of cases you can point to of initiative-driven referendum or citizen-driven referendum not, put on the ballot by the city council that were binding?
Well,
I think our city
yes,
manager.
the answer is no. The answer is in the last election in Dalton, the village of Dalton, voters wanted to modify their council and the way their government operated in Dalton. They didn't put 1, 2, but 3 referendums on the ballot. One of them was for nonpartisan elections, similar to what's on the ballot here. A second one was for reducing the size of the village board from 6 to 4. And the third referendum was to have term limits on the officials of Dalton. 3 referendums, the voters had 3 different choices. This was all pursuant to 28-7 of the election code and also empowered by the Constitution, which is Section 11 of the Constitution. So that's what they put on the ballot. The voters turned down narrowly 2 of the questions. They didn't want nonpartisan, and they didn't want a smaller council. So then, finally, they voted yes for term limits. So 1 out of 3. But that's exactly what the constitutional delegates and the voters wanted in 1970, a laboratory of democracy.
So
not everything is going to pass. And
are there a bunch of other, 1970 was a long time ago, and there's been a lot of referendums, I imagine, in Illinois that have been on the ballot since then. How many of those, again, citizen-driven referendums not put on the ballot by the city councils have been binding?
Well, every single one. Illinois has about 25 municipalities that have term limits on their local officials. That includes Springfield, Naperville, Des Plaines, Oak Lawn, on and on. 25, all 25 of those were binding referendums, most put on by petition, but not all. A few, Brookfield decided they were going to have term limits put on by the city council there, and that's what happened. But most of those were done by initiative petition. Now, a number of communities have used what you're doing here, or seeking here, nonpartisan election. Some of those have been put on the ballot by petition. Some have been put on by resolution of the council. The idea that somehow the resolution of the council has a higher standing than the initiative petition of the voters is not correct. They're identical. They have the same power, whether it's a city council doing it or the voter initiative doing it. It's co-equal. There's no more authority for one than the other. And
Why? Sorry, I just want. Why would anyone just do an advisory referendum if we can do binding referendums that are citizen driven? I mean, I'm just thinking that we had Harley Clark, and, so there was a citizen, it was an advisory referendum. The council then afterwards chose to vote in support of where the referendum was, which was dealing with a mansion. But
that's an alternative way.
But why do people even? I mean, why don't they just do binding? I guess. I mean, why go through all the effort, get all these signatures just to do advisory when, man, if we can get this passed, it's binding on our city.
Now, first of all, what the Evanston Voter Initiative is seeking to do is modify the process in Evanston, where if people gather signatures on a petition, it goes before the city council. The city council has a period of time, I think it's 70 days, to reflect on it, decide it, vote on it. Then it goes on the ballot. If the council doesn't pass it, the voters can vote their conscience, vote yea or nay. And after that's over, the city council still has the power, after the referendum, to disapprove the referendum. It's a new way of doing it.
But why go through all that effort as opposed to just putting?
We're not hearing the question. If we can just get to the heart of the question. The question is why wasn't the Harley Clark referendum a binding referendum?
Yeah, it was not pursuant to Article 7, Section 11 of the Constitution. It was pursuant to a different part of the election code that allows for advisory referendums. Illinois has had that law since 1901. But some people, for example, in Arlington Heights and perhaps here in Evanston, want a different way of addressing issues than what exists now in the state statute. The constitutional delegates and the voters who adopted the Constitution in 1970 made it clear that if voters want a different way of operating in their local government, they're free to do that if they gather enough signatures, as Evanston has here, to put that new idea on the ballot, modifying the way the government works. And, I think it's healthy to have this. The cases that involve Arley Clark, if you read those decisions of this electoral board, and especially the decisions of challenging of candidates back in 2017, to their credit, the board at that time said, ballot access means something. It's fundamental. It's not a trivial right. It's a substantial right that shouldn't be denied. And that's why they went forward. You dismissed or overruled the objections on Harley Clark. You overruled the objections on the candidates against the clerk or the mayor. And I think that principle still applies. And I think that this board needs to defend that right and not obliterate it.
So I'm sorry, just one more. So how do we deal with a situation with this referendum? And I guess this gets to their point, or the objectioner's point, about it being confusing and conflicting with other rules and procedures that we have as a city. So I think, we have lots of things around town. Some of them are controversial, and some of the developments are controversial. So if I think about one development we had recently called Albion, to get that approved, it took a supermajority, so 6 out of 9 council members. Let's just take that for example. And so there's a referendum that says, don't approve, this Albion development. So it goes through this whole process that you guys describe in your referendum. It comes to the city council. I guess I'm trying to figure this out. It requires, if they take no action, then the development doesn't go forth. It's rejected by this referendum, which is this ordinance, I guess.
Not exactly. If the voters vote on a referendum dealing with a local project,
development project,
they can express their opinion, the voters, but the council has within it, according to the terms of the Evanston Voter Initiative, they have 30 days to disapprove what the voters did.
Yeah, point of order, we shouldn't be discussing the merits or the actual case. I think that question was a bit off.
I don't think it was. I thought it was trying to get to this ambiguity of the second point they were raising, that it's confusing, because it's just confusing to me.
Okay.
But I'm easily confused, I guess.
But, Mr. Mayor, the law of Illinois is, are voters given a choice at the ballot box? The Johnson v. Ames case dealing with term limits in Broadview, the court expressed great impatience with those who are saying, well, it could be interpreted a different way and this and that. The court said, following Huguzian and other cases, that there's a clear choice here for the voters to make, yes or no. Now, the court also made it clear that you don't have to put together a question on the ballot that meets every single person's view of what's simple and easy to understand. The court said it's enough that voters have a choice. That is the red letter law in Illinois. The very idea that the objectors in this town of Evanston are bringing up that Evanston voters can't handle the yes or no of this question is, I think, way off. The facts are that 3,871 people thought enough of the question to sign the petition and put their name on it. That's a serious matter indeed. And so I really don't feel that this board should take seriously what they're trying to say with respect to count 2. And with respect to count 1, they don't recite anything about the Illinois Constitution and Section 6 at all. They, you can't make up their objection for them. They have the burden under law to carry out their objection. And they've put together something here that's doesn't even bring up 28-7 or bring up the provisions of the Constitution, Section 6 as well as Section 11. And so, they put together an invalid objection that has no merit, and now they're trying to keep people from voting on it, and that's 49,933 people who are registered to vote here in Evanston. And in the leading case on initiative is when this board looks at the matter, it has to look not only at the petition passers, who obviously care about it, but and also the signers who signed it, over almost 4,000 people. But you got to also look at the voters. Their rights are intertwined now tonight with the petition passers and signers. So for this board to go along with the objectors is really violating the voting rights of 49,933 people. Their rights are intertwined here, and let the referendum take place. If the opponents want to say to the people it's a bad idea, that's democracy at its best. But it isn't democracy at its best if the board decides to cancel a referendum and keep people from having their rights protected.
Thank you. Alderman Clark Reed?
Yes, I have a few questions. One question, just hypothetically to the objectors, or not hypothetically, what you mentioned in your objectors petition as well as in your statements here that the referendum, part of the confusion of the referendum, of the question, is that it would require amendments to the code, to the Evanston Code, in order to be enacted. Can you go into that a bit more?
When you said that the petition, the referendum question is not self-executing, and
yes,
providing for this new additional process for enacting local law, there are going to be inherent conflicts with the existing way in which law is passed in Evanston, as expressed in the Evanston City Code. So, for example, it leaves gaps to be filled in that will need interpretation in order for the referendum question to be implemented. How does operation, the mayor has a veto power, how does that operate in relation to these referenda questions? That would have to be resolved. There's a conflict in that process for how it would be resolved. Where the council rules require a supermajority vote, how would you resolve those questions, those inherent conflicts between what the Evanston City Code provides now and the council rules and what the referendum is providing as an alternative process? So in cases where a referendum question is not self-executing, that it leaves these gaps to be filled in by amendments to pre-existing law, that is grounds for denying a petition or a referendum question. Thank you for asking.
Yeah, I have more questions, but I'd like to hear a response from the objectors regarding that.
What we just heard is not in the four corners of the objection. This is an amendment to the objection, which is strictly prohibited by law. It has no merit because it is self-executing, and the voters have a right to vote on it. If the voters don't approve it, then the initiative doesn't exist. So what they're trying to do is conjure up a hypothetical situation that may or may not happen. Courts and electoral boards do not entertain hypothetical questions, especially in the case that this objector did not include any of that material in their objection. And so if they wanted to put it in, they could have, but they didn't. And they now are not allowed by law to bring it up.
Thank you. Do you want to, is it within, I mean, I'm looking at it now, but just for the record, was that within your objection?
From our perspective, the confusing language, the compound sentences, the inherent conflict within the language of the referendum itself puts forth just this argument. We did not say not self-executing in the objection. No, that's true. So
in that case, we shouldn't be considering that, I think. But next, to the objectors, our term, well, again, this is to council. This is within the memorandum that we received to this, and I don't believe this is within the four corners of the objection, but I do think that this should be addressed. Are term limits expressly allowed by the Illinois Constitution? Are term limits, so in the memo that you provided us with, you state the applicable law relating to 6F, and you say that the whole nature here is that the proponent's proposed ordinance initiative procedure is not, quote unquote, provided by law in any constitutional provision, statute, or ordinance. Are term limits provided by law in the Illinois Constitution?
Terms are a different part than altering the form of government provided by law. That's a different clause of 6F. And I think council read it.
It's not considered a form of government.
Can I have the objectors answer that?
Proponent.
I'm sorry. The proponents.
Well, there's two sections. There's one called the form of government, provision of the section 6 of Article 7. Form of government, you can alter it, you can repeal it, you can adopt it. Then there's a second section. It's called the officer clause. You can provide for your officers their powers and duties. And you can provide for their manner of selection, nonpartisan or partisan. And you can provide for their terms of office, including term limits.
Okay.
Okay. And that has been done, as the question the mayor had. How many petitions have been filed under Article 7, Section 11? Well, I would say dozens and dozens, if not hundreds. Voters have used this all over the state to deal with these two subjects, changing their form of government or providing duties for their officers, as well as term limits and manner of selection.
Okay. I do know that in, what was the year that you ran?
73.
No.
93.
93, yes. I do know in, I believe, 1990, there was a referendum that reduced the number of council members from 18 to
9.
to what we have today, 9.
We have today.
And that was a citizen-initiated referendum, correct, Alderman Rainey?
Yes.
Yes.
So it's pursuant to
6F. Does the Constitution expressly allow for the recall of elected officials?
Well, that's a very interesting case. In 1981, a group of people in North Lake wanted to establish recall by initiative in their town. Keep in mind that Arlington Heights had passed an ordinance putting a referendum on the ballot the year previous, and the voters voted for it. And several other home rule communities had done the same. The people of North Lake are not home rule, but they have the right of initiative, as any community does. The case went to the appellate court. The appellate court said, no, you can't do recall by an initiative petition. And for some time, people thought, well, that's the law of Illinois, until 2016. The appellate court of Illinois, in a case, Henyard v. City of Dalton, or Village of Dalton, held, the cases of Leck and Lipinski, U.S. or Illinois Supreme Court cases that were decided in, I believe, 1986, overruled the North Lake case. Williamson v. Doyle was the name of that case. And in fact, you can have recall pursuant to Article 7, but it must be accompanied by a referendum. That's what the current law in Illinois, in this county, and especially Cook County, that's where Dalton is. The appellate court said if people want a petition or if the city council wants to put it on the ballot by resolution, you can have recall as long as the voters approve it in a referendum. That's the law today.
So, but recall isn't expressly, the power of recall isn't expressly delineated in the Illinois Constitution.
The constitutional debates were very clear that they were not going to put in the Constitution only the things you can do. They weren't going to self-limit that way. They were going to have these broad terms that could encompass lots of ideas that people may come up with 50 years later that maybe didn't dawn on them back in 1970. They wanted to have wording such that it promoted what I said several times earlier. The dominant theme of the local government article is flexibility of form, of structure, of powers. And so that's what the delegates and the voters wanted. They wanted total flexibility because they didn't want what happened before 1970, where if Evanston wanted something for its own local affairs, they'd have to go run it down in Springfield. That was the law back then, and it got overturned totally by the new Constitution.
Thank you. And the objectors, do you have a response to that? And to our board attorney.
Yes.
So here in what was provided, do you agree with that assessment that recall is not expressly granted by the Illinois Constitution, but voters have the power to do that, to implement it through initiative?
What Henyard said, and this is according to the election law chapter of the ICL.
What is the ICL?
The ICL is the Illinois Institute for Continuing Legal Education.
Thank you.
Thank you for helping me make a clean record.
Yes.
But it says, although Illinois does not generally allow recall of elected officials by initiative and referendum, this power encompasses the ability to enact an ordinance with referendum approval to establish a procedure to recall local elected officials, citing Henyard.
Can you repeat that again? I apologize. Sorry.
Although Illinois does not generally allow recall of elected officials by initiative and referendum, this power encompasses the ability to enact an ordinance with referendum approval to establish a procedure to recall local elected officials. And that's Henyard versus the Village of Dalton, 2016, ILAP 1st 153374. So, again, it's like Flowers versus Moline. It's the ordinance came first and then the referendum.
So it wasn't a citizen-initiated.
Wait a minute here. I think you're confusing the matter. The fact that the council has the power to put a recall ordinance on the ballot as a referendum in Dalton means the voters have the same power. Do you agree?
I don't think that's what this says.
That's what the disagreement is.
How, I have the case right here, the appellate court case.
Okay.
If the council has the power by resolution to put a binding recall referendum on the ballot in the village of Dalton, pursuant to Article 7, Section 11, then the voters have to have the same power because they're co-equal. The voters do not have less power than the council.
If I can, I believe that as a general principle, but can you tell me where in this context you get that idea that residents have, because I think the thought of, I think the thought of people on the board is that we're elected to these offices and there are certain authorities that the voters give to us, I think. And so what is...
Okay, here is the Constitution. It's Article 7, Section 11. And it says proposals for action, let's say whether it's for recall or nonpartisan election or initiative, whatever, that are authorized by this article, that require approval by a referendum, they may be initiated and submitted to the voters in one of two ways: by resolution of the governing board of the unit of government, or by petition of electors in the manner provided by law. There is no difference in the power of putting something on the ballot between the governing board or the voters. If the voters wanted to have nonpartisan elections, they could have petitioned that 2 years ago, ahead of the city council. They have the same identical power to put questions on the ballot pursuant to this section of the Constitution. I can't believe that you don't agree that in Henyard, if the city council can put a binding referendum on the ballot for recall, as long as it's approved by referendum, that's what the court said in Henyard, then voters have the same power.
But Article 11 says that the proposals for actions are authorized by this article, and the 6F that you're relying on, they're powers of home rule units.
No, home rule units and non-home rule units have identical powers in both of these areas with respect to providing for their officers and their manner of selection. There is no difference between a home rule unit and a non-home rule unit in this area of the Constitution. And that's what the Henyard case made very clear, that recall, they said, is a manner of deselection. That's what the court said. This is deselection. It alters the terms, it also says. And in so doing, the council can put it on the ballot, said the appellate court, if they want, but they have to get approved by referendum. The problem in Dalton was they didn't go to referendum. They just passed an ordinance for recall. That's not good enough, said the court. You got to have a referendum. But in so saying that, that also meant that voters had the same power to put a referendum on. And that's true here. Arlington Heights put initiative on its ballot in 1981 by action of the village board. In this case, voters are trying to do the same thing by initiative of the voters. Voters passing petitions. So, you know, the idea of having these referendums, the Constitutional Convention, as I've said repeatedly, was very concerned that units of government would kind of gang up on the voters and keep their questions off the ballot. And that's a very key issue for this electoral board. Are we going to let the full power of the initiative in the Illinois Constitution and the local government article take place, or are elected officials going to try and censor it? And, you know, the courts are very clear, you can't do that. You have to let the voters have their chance at the ballot box. And that's what the objectors should do here, too. They, should let the voters have their crack at it.
Thank you. Any other questions or comments? Or I'm thinking a recess.
I make a motion to recess for 5 minutes.
Yeah, let's say 5 or 10. I want to make sure people get an opportunity one-on-one if they want to up here to speak with the council. So I'll second that motion. All in favor?
Aye.
Okay, we're going to recess. Okay. Welcome back, everyone. Is there a motion to resume?
Motion to resume the meeting.
Okay, all right, all in favor, aye. Okay, so this meeting is now resumed. Clerk Reed, I'm going to grant the floor to you. I know you had a couple of questions or comments.
Yeah, I think we're moving toward the part of the night where we make a motion for a determination by the board. I do have a few other questions before we move to that point. So with that, I'll get into it. So what section of the code, if you can just refresh my memory, allows for the alteration of responsibilities for officers? Is that 6F or what is that?
In my Constitution.
Or
out here.
board council?
No,
or objectors? Yeah.
The Illinois Constitution, in the local government article, which is Article 7, for home rule units, which this is what Evanston is, it's section 6F.
6F.
And it allows a home rule unit to have the power to provide for its officers, their manner of selection, their terms of office, by referendum.
And their powers and duties?
The powers and duties of officers, that's what the Flowers case said.
Okay, and to our board council, because this referendum, alters some of the clerk's responsibilities, it alters, the powers and duties of the council as it relates to passing ordinances. Would you say that, in your opinion, you think it fits within that? Maybe there's some gray area, but would you say it fits in that alteration of officer responsibilities?
I think that's a good question for the proponents. Which clause are you relying on of 6F?
We're relying on both clauses, but specifically to the question, it clearly provides new duties to the clerk, to the council, to the mayor. It's the powers and duties of the mayor and the council and the clerk are provided for in this question. And it specifically said so at the very beginning of the question that's on the ballot, that it's giving the voters a chance to alter the powers and duties of their municipal officials. I will point out that in Arlington Heights, when they put their question on the ballot for initiative, and I do think this board should keep that in mind, that there has been one example of this being done in Illinois without any legal objection, and it stood for almost 40 years. But Arlington Heights recited both parts of Section 6F. Basically, they said they have the power pursuant to 6F to change their form of government, alter it, as well as provide for their officials.
And just so I'm clear again, in Arlington Heights, which is, I guess you're saying, the most similar to what this referendum is that?
Arlington
of the
Heights
cases of-
actually goes a little bit farther than what we're proposing here in Evanston.
Okay.
Arlington Heights, if the voters approve an initiative, it automatically becomes the ordinance of Arlington Heights. They're free to repeal it the next day.
Okay.
Here, if voters approve a proposed ordinance, the council has 30 days after that referendum to disapprove it, basically veto it.
Okay.
That doesn't exist in Arlington Heights.
Got it.
So in many ways, this is a way for people in Evanston to bring to the attention of the council and the mayor ideas. The mayor and the council may adopt those ideas and pass them into the ordinances without any referendum whatsoever.
Okay.
If there is a referendum, the voters give their advice, but the council has the total power under this proposal to say no. So that they retain their power to enact an ordinance. If they say okay, then it's an ordinance, but if they say no, it's not.
And
Arlington
again,
Heights does not have that.
I know in the case of Arlington Heights, the elected representatives on the city council placed that ordinance as a referendum. So they voted and placed it there. Your argument today has been they didn't even need to do that. The voters themselves could have just put that referendum out there,
There's
right?
two ways to do it.
Mm-hmm.
The council in Arlington Heights, I believe by a 7-1 vote, put this idea of initiative on the 1981 April ballot. It passed handily. Now, the very fact they had the power to do it, the council did, means that the voters, under our Constitution, have the same power to put that idea on the ballot. Ultimately, it has to pass by referendum. If it doesn't get a referendum approval, then it's
Got it.
dead.
Okay, thank you. Go on, Clerk Reed.
Okay.
I have one question.
Oh, go ahead.
How many instances, I'm sorry, how many instances of enacting an action under the Arlington Heights referendum have there been?
The idea was to have it on the ballot in 1981, and the people passed it. To our knowledge, it hasn't been used in Arlington Heights. It's on the books. It's part of their municipal code. If you go to the internet and look at the Arlington Heights Municipal Code, which I have a copy here, it's still there. It's
Why
part
do you
of-
think that is? Why?
It's up to the people. It may very well be that folks in Evanston will have accomplished putting this referendum together and passing it. It's premature and hypothetical to say that it'll ever be used. It's up to the voters. To begin to use it requires a substantial number of signatures, but what they found in Arlington Heights, it's affirmation that the fount of our government is the voter. In fact, I recently came across a Supreme Court opinion of Ruth Bader Ginsburg, who, in a case, Arizona State Legislature versus Arizona Independent Redistricting Commission, Justice Ruth Bader Ginsburg wrote the opinion supporting the Independent Redistricting Commission that had been adopted by initiative by the people of the state of Arizona.
Just before we get into that, one of the things I was thinking about, which has nothing to do with the objection or anything else, but on the Arlington Heights case, I was thinking 49 years, about 49 years, maybe.
39.
No. 39? 39? 89? Okay, 39.
Long time.
A long time, real long time. People go to their elected representatives without going through all the petitions, and, I mean, I know the Evanston City Council will roll over if 25 people come to the microphone. And it's not necessary to have like 2,000 signatures sometimes. Anyway, so maybe that's why. Maybe the Arlington Heights Council is very responsive, and it wasn't. There's a reason why it hasn't been used, and I'd like to look into why that is.
Well, as far as this,
It's a statement. It really is a statement.
Yeah, as far as this body is concerned, it doesn't affect the decision that has to be made tonight.
I
It's
did want to
interesting.
recite
Very interesting.
Justice Ginsburg,
Can't
Ruth
disregard
Bader
it.
Ginsburg's phraseology. She said that the invention of initiative was not part of our Constitution when we started as a country. It came along later, but it's in full harmony with the United States Constitution. That's what Justice Ginsburg said in this leading case, because it understands that the fount of our democracy are the people. That's why it was passed, the initiative. Whether it's used is not really subject for this hearing.
I
It
agree.
may never be used.
I agree.
But the fact that voters get to vote on whether to have it is a subject of this hearing. And in the recess, I did kind of look up a couple of things here, that the Electoral Board of Evanston, to me, I've read your cases, I think has a distinguished history. And back in 2017, one of the appellants said there's a strong judicial philosophy in favor of ballot access in the case. It said it's a substantial right that may not be lightly denied. That's the Welch versus Johnson case of the Illinois Supreme Court. But then it said it's a fundamental principle that access to a place in the ballot is a substantial right not to be denied. That's Nolan versus Cook County Electoral Board back in 2002. So your decision today, you know, Mayor Tisdall was a mayor back then, and she was on this board, but she voted for ballot access for all those candidates. We know that there was kind of a confusing situation in 2017, and rather than, you know, deny access, the board, I think, prudently and rightfully decided it's better to let the voters have a chance to vote for all the candidates, not to knock people off the ballot. Well, that same principle applies here. You have the example of a city in Illinois, about a little bit larger perhaps than Evanston, Arlington Heights, using in 1981 this particular provision to enact an initiative ordinance. The coalition case says, you know, the rights that are at stake here are not just the people passing petitions or even signing, it's all the voters. And so we'd ask this board to think of all the voters of Evanston. What is the best way to have equity and fairness? Isn't that really what this question is about? What's fair? What's equal? And the right of being able to vote is pretty darn important. And if the objectors have a problem with a particular ordinance, even if this is passed, then they have a right to challenge that in court, because any challenge of an ordinance now is premature, it's hypothetical. The courts would never entertain it. So this is really a question of whether the referendum is on the ballot with a chance for the people to speak.
Thank you. Mm-hmm.
If I want to take the floor. And I guess the first thing I'll do now that I have the floor is make a motion to overrule paragraph 1 of the Objectors Petition. Is there a second to that?
Okay, is there a second to that motion? Seeing none, are there any other motions?
I have a question.
All right, Alderman Rainey.
I'm not an attorney, and I don't fear asking stupid questions, so I have no fear. Why is this better? Why is this referendum better than the normal referendum route? The normal referendum. Anybody can gather signatures and place a referendum on the ballot. Why is this better?
Okay. But again,
I really want to know.
I know.
No, I can't ask that question.
no, I think let's just stick to you know,
That must
whether
be
this
a
is
really
valid
stupid
to be on there. You know, there'll be, you know, I don't think that's appropriate here. So is there any other motions though on paragraph? And this is on paragraph 1.
Yes, I have a motion then. That could mean the difference in my vote. All right, I have a motion, and my motion is I move to sustain paragraph 1 of the Objectors petition.
I second that.
Okay.
Okay, all in favor?
Well, I do
we can do a roll call vote.
Yeah, I do want to discuss that. So I have issues with for a number of reasons with sustaining the objectors paragraph number 1. You know, I am uncomfortable with 1. I do not feel. I think there's merit to it. And I think the objectors brought this in good faith. I do not think the objectors made a solid case. I honestly feel as though our board attorney made a better case for removing this from the ballot. And so I am uncomfortable with supporting it because I do not feel within the four corners of this objection the threshold has been met to remove this from the ballot. And as we have seen in the 2017 cases of the Electoral Board, Evanston has a history of supporting ballot access and ensuring that the voters have an opportunity to weigh in on on the selection of our officers or important matters like this. I do feel as though, based on the arguments that we have heard today, that this does meet the thresholds of, Article of the Election Code and of the Illinois Constitution, 28.7 and 28.6. I do think that the cases that have been cited do sufficiently make the case that paragraph 1, as it is presented in the verified objectors petition, that it does not meet the threshold for removal from the ballot and denying the 49,000, almost 50,000 Evanston residents the right to vote on this matter.
Thank you, Clerk Reed. So the motion to sustain the objectors petition for paragraph 1 passed on a 2-to-1.
We didn't vote.
We need to vote.
Oh, I need to do a roll call vote. Excuse me then. Okay, Clerk Reed.
I vote no.
Alderman Rainey.
Yes.
Mayor Hagerty, I vote yes. So it passes on a 2-to-1 vote to sustain that objection. I'm now going to move a motion that we adopt a...
I don't know if you can't move the motion.
Excuse me. Oh, I got to do paragraph 2 first? Okay. So is there a motion on paragraph 2?
Or if I have the floor, I make a motion to deny, to overrule the objectors, paragraph 2.
Thank you. Is there a second on that motion? Okay, seeing there's no second, is there any other motions on paragraph 2?
I move to sustain paragraph 2 of the petitioner's motion. I move to sustain the petitioner's the motion. I move to sustain paragraph 2 of the petitioner's motion to object.
Okay, that the referendum question is confusing. Okay, is there a second to that? I will second that. Can we take the...
If I can make a
You
comment
can, if
here.
you'd like to make a comment before we take the roll.
Yes, insofar as paragraph 2, I do believe, while I believe there was merit in paragraph 1, as an Evanston voter myself, and I respect all of the objectors there, but I do feel it is it's a bit insulting to our residents. We have a highly educated populace. We have a brilliant city to say that folks could not understand this referendum. I'm not a lawyer, and reading it, I understand it, and so I think Evanston voters are smart enough to be able to understand this, and I think that if we vote, particularly on this matter, we're saying that our voters can't understand, fairly straightforward language, and I think that's an insult for this board to say that about our voters.
Thank you, Clerk Reed. Alderman Rainey, did you have anything?
Yes, I'd like to say something. I don't think it's insulting at all, and it's not so much that if they studied it for a while, we wouldn't all understand it. However, I will tell you that I talked to several people passing the petition who could not explain it to me when I asked them, what is this? Because I had looked at it one time and I didn't understand it at first reading just by glancing at it, and the passer of the petition could not explain it to me. So I don't think that the objectors were saying that the community is stupid. I think they were saying that it is poorly written and difficult to understand. That's what I think they're saying. I sustain paragraph 2.
Thank you, Alderman Rainey. Okay, so I'd like to take the roll call motion on the motion that we sustain paragraph 2 of the objectors' petition that the referendum question is confusing. Clerk Reed.
No.
Alderman Rainey.
Aye.
And I vote aye as well. Okay, so that motion passes 2-1.
And I have another motion.
Okay, Alderman Rainey.
That we prepare the appropriate written decisions indicating our sustaining of both paragraphs.
I'll second that. Or is there a second to that? I'll second.
Point of clarification, is this a motion to adopt the written decision?
To adopt and prepare the appropriate written decision.
Thank you.
Okay, is there a second? Aye.
Second.
Well, all right, aye. Any discussion on that written one? So just so people here are aware, the outside counsel drafted a whole bunch of different ones depending on where this ended up this evening. To sustain the paragraphs, I just noticed, I'm not sure, it said, if that, I just want to make sure that, right, to the voted on, or I wasn't sure if that should be voters. Anyway.
It can be voted on. I can correct that.
Okay, so I just wanted to, I got like just that, maybe one other minor thing that I just wanted to point out. So can we take the roll then on adopting the written conclusion of the board? Okay, Clerk Reed. I just want to make sure, did I state, hold for one second, I just want to make sure I get this stated properly so as to not mess anything up.
Sure.
Alderman Rainey, moved that, I seconded it, it was I just want to make sure I get this right.
Right, it's just a written decision. And
It's the motion to adopt the written decision.
Mm-hmm. So
Okay.
there's a motion, and I just want to make one statement. I will be voting yes to adopt the written decision because it's the written decision. But I do, just for the record, want to state, and moving forward with electoral board proceedings, I just want to put on the record my discomfort with the fact that the council did prepare a number of board decisions, but the only one that was fleshed out and substantial was the one where both objections were denied. And I do wish that in the future, and I hope to retain Ansel Glink, and particularly you, I enjoyed the conversation that we had earlier and having high level conversations about election law. But I do hope in the future that we do a better job of presenting both sides to the electoral board, and particularly when we're writing these decisions before they're done, I hope that in the future all of them are very well fleshed out, and there isn't one in particular that.
I thought they were all, well done here in terms of all the options that we had. Did you want to add anything?
These are These are expedited proceedings, and I'm sorry to hear you were disappointed, but we did our best and presented the law as we as we thought the law provided.
All right, thank you. Okay, so Clerk Reed? So Clerk Reed voted you to adopt these written, and you made your statement to that. Alderman Rainey?
Yes.
And Mayor Haggerty, I vote yes as well. So those are adopted, 3-0. So City Attorney, can you just talk about sort of what comes next?
Sure. If the parties can stick around, we could finally resolve this matter tonight and serve this written decision on you in open proceedings as we're required to do. But we'll have the board execute the decisions and make copies. We do need to have public comment. If we could go off the record for public comment, keep taking the court reporter for minutes purposes, but we'll come back on the record at the conclusion of public comment to that my suggestion is, so we could serve these decisions on you in open proceedings. Alternatively, if you don't stick around, we'll serve them on you by mail, but hope you stick around.
All right, thank you. Okay, so while you're working on that, and we'll get the signatures and everything, we'll now open it up for public comment. So Jackson, I see that you'd like to say something. So after Jackson finishes, and I think we'll keep these under 3, but let's try to keep them under 3, sort of our standard. And then if there's others, so Jackson, and just introduce your name and everything.
Jackson Tyler, first word. I won't belabor this point long. I can accept that the objectors brought this in good faith, but given that part of the law is the burden was supposed to be on them to make their case, and I saw Governor Quinn receive like 90% of the questions, and it's kind of astounding that this board rendered a ruling that flies in the face of the law.
90% of the
And I
time.
share Clerk Reed's discomfort that it seems from my point of view back there that this board's counsel clearly made up his mind before the hearing. I think that it irrevocably tainted it.
Thank you, Jackson. Others, Miss Esther. Let's just.
My name is Betty Esther, and this process is interesting, has been interesting. The process that went through when we had the Board of Election and candidates getting on the ballot, it did not take this long of go into this much history. I did learn a lot, and I can agree to that. But when you keep stating rules, regulations, and laws, and reading stuff, and they are saying what the objective did and took asking for and what they did not follow the procedure, and then you voted for it, it's kind of confusing. That is like when you get the referendum to dissolve the township. That was in front of, you did an advisory question. You took it out to the community and said, well, we don't want to say that we are dissolving the township. We want the people to do this. So you asked the people, should we ask our representative, Mr. Schoenberg, to go to Springfield and ask for this to happen? And some people said yes, some people said no. If you're talking about confusing language, that was a confusing language referendum. We debated it. I did most of the talking and stuff. So you said yes, he should do that. So then he went to Springfield and he got the vote and it came back. But then you had to have another referendum because Springfield said you cannot dissolve the township without a referendum. That referendum in that language, the language was clear and it wasn't confusing. And to the point that maybe some people couldn't articulate it, what you thought was clear enough, that's one thing. But when the people, when that came to vote and the opponents that was for the dissolving of the resolution, which in fact was the city, did make that language as confusing as hell to the voters. And even to the day, they keep asking, well, it wasn't clear. Why would we say one and not the other? And all I told them, you read the question. All you have to say to the voters is to read the question. The voters get that question either 2 or 3, maybe 2 months, I'm not sure how many months beforehand, before they go to the poll so that they can study and make a informed decision. So let's not start saying they won't understand it and use that as a reason for voting for something. That is not a valid reason to vote, to abstain this objection. So it should have been denied.
Thank you, Miss Esther. Okay. Let me go around there. Let me go around. I'll get to you at the end. I'll go Karen. I'm going to go the whole thing and then back to Allie. I mean, she's had her attorney here and had quite a chance, so okay.
I'm Karen Courtright, and I'm really bummed tonight. Mayor Hagerty, I have loads of respect for you, and yet all of your questions were revealed quite clearly that you had made up a decision without hearing. You were asking the Senate that were inappropriate. The council, I'm just stunned by. Last week, he couldn't even keep the words petitioner, objector, reply, and response straight. And the fact that the only fully completed document was one for upholding shows to me only one thing, of prejudging and your willingness to support these 3 people as opposed to 3,900 petitions.
Thank you, Karen. Bob?
Bob Cruz. I heard the opposition bring up the fact, a question on Clerk Reed's objectivity, and I'd like to bring that up with Alderman Rainey, who I spoke to at Titan Ridge. May be the person that couldn't explain it very as well. But I also asked the mayor at the parking lot out here if he would sign the petition, and both of you were against signing the petition at the time. And I suppose you can have your own opinion, but I'm curious why maybe all 3 of you haven't recused yourselves.
Thank you, Bob. Let's see. Anybody else on that side? Meg?
You asked why this referendum was better than an advisory. And the purpose of the Electoral Board is not to decide if this is a good idea. So I think your question was very revealing, and then you went right to a motion to uphold the objector's position. And I think it's very revealing. I know that you're purporting to be just calling balls and strikes, and that the objectors, objection, technically they had a case, but it's just not very convincing. So let's be clear what happened here. We have a city council that can put initiatives on the ballot. You have that power. You also would have the power, if this passed, to overrule any ballot petition that was passed by a majority of the voters. And so there's just seems an obvious unwillingness to power share here. And when you remarked that it's routine for the council to roll over after 25 people do public comment is absolutely hilarious. Because the very reason why this has become an issue and why we have this initiative is there has been issue time after time after time. When thousands of Evanston residents have signed petitions, they've emailed their representatives, and we're told, well, we don't know, it's the squeaky wheels, we don't know what the majority really thinks, on and on and on. I can cite 5 recent ones. So that is really ridiculous. And I just want, to really highlight what is happening here. And that is that you are disenfranchising the people of Evanston, the voters of Evanston. This was a political decision, and everyone knows it.
Thank you, Meg. Okay, Mary. Yeah.
I would agree with everyone who spoke already. I also want to say I felt watching this was such a sad state for our residents and for any form of democracy, because it was clear that the opponents didn't have to defend themselves because our attorney was doing it. But also, this is about confusion. When the Civic Center referendum was up in 2007, the city put out a public and do it. They got the city, this electoral board to do their bidding, and that's unfortunate. I also think we need to really look at our electoral board, and we need somebody, a group that's more independent. I think maybe the people who somehow or other are from out of Evanston, definitely not out of Evanston. I mean, if it's the native women, if it's whatever it is, because this was, did not feel very good.
Thank you, Mary. Yeah, why don't we go up front here, and then we'll go to the back.
My name's Bill, and then I just did realize that the board's supposed to be what I would call impartial and fair. But my only question is, I noticed that Ms. Graney only spoke 4 times, and to me, the lack of engagement proves kind of a bias. So I was just wondering why that would be.
Thank you, Bill. Sorry, we can't have a whole dialogue here. Let's go. Is it Darlene that's back? I don't have my glasses. Let's go to
Carolyn.
All right, Carolyn. Excuse me, Carolyn. I'm sorry, I can't hear you. I need my glasses on. I can't see far distances.
Issues that would come up in the electoral component again, that we as a city seek to get something more independent, because sensationally all 3 of you have had so many issues legally, ethically, that I just find it very hard for you to have made a decision in our message.
Thank you. Ray, did you have your hand up earlier? Ray Friedman? Okay.
Ray Friedman, 2nd Ward. I've only been in Evanston about 4 years. I met Darlene next to me here. Are you sure?
I am sorry. I am nearsighted. I have my glasses on now. I can clearly see Darlene is to the right. I am sorry, folks.
So, as you all know, that I began speaking in public comment because of the 16-unit built at Dempster and Pittner. The building apparently is empty. We paid $5.5 million for the building. Doesn't have a valid zoning permit, or I'm sorry, zoning approval. It's not valid. And it's not what it was proposed to be to begin with, which you all know. My question is pretty simple. It seems that since I've been speaking for like 2.5, 3 years, it seems like City Council is consistently voting against the residents. Time after time. And like Meg said, I can mention 6 instances where at Welsh Ryan Arena, you had the guy on the Scott Ingold that was on the zoning board for 10 years, and you didn't listen to his opinion, and you went ahead and approved it anyhow, even though he said, no, you can't do it this way. You gotta follow the zoning ordinance that you said. Why do you have the zoning ordinance if you're not gonna follow it? So this seems pretty simple to me. I mean, we're asking to put a referendum on ballot. I mean, we're not voting on anything in particular, and you all, the council, has the authority to say no. And I don't understand that how you could even think about saying no. Well, it doesn't make any sense to me, and I don't understand why you keep on voting against the residents. And you have thousands of people that and the Albion, and on.
Right.
It doesn't make sense to me.
Thank you.
At some point, I asked 2 days ago, what was the reason, the 9 aldermen, what was the reason you ran for office? What's the purpose? What did you want to accomplish? Okay? There needs to be a reason. So, is it to represent the people? Because we're not getting represented here.
Thank you, Ray. Evie Russell.
Yeah, what stunned me is that Quinn here presented law cases, Supreme Court cases, appellate court cases. Those are the law. And according to the law, the way you voted against the law. So that to me is totally clear. I don't have a question of why you voted against the law. I know very clearly why you voted against the law. One possibility is that you are just following the same trumpet as the Senate is doing. So that's not the question. The question is that you are actually doing things that are against the law. The law clearly stated, as it was presented in the cases, that's what, when a legal counsel presents a case, it presents the cases that went before. And to say, oh well, but those were years ago, that's history, it doesn't count, reminds me of other comments at other councils. This is the way the law works. And I think that some of you should know the law. And you obviously choose not to follow it, like people up higher in our government. So you are just like them. And what comes around, what goes around, what does the Americans say? It will come and get you, eventually it will bite you in the ass.
Thank you, Evie. Yes. If you, yeah, not up, Beth. Yeah.
Fractured democratic system in our city, suppressing the voters. And with the law on the petitioner's side, it makes me really sad to see that the decision was already made before we even arrived tonight. The documents were already prepared, the arguments were already laid out. Is an insult to the democracy that you're supposed to represent and the impartiality.
Thank you, Beth. All right. Is there anybody else out in the audience? I know Allie wants to say a couple things, so I'll let Allie wrap it up then.
Do you want to?
We'll do that when we get there.
I want to start by saying thank you to the Honorable Pat Quinn for inspiring us to initiate this process. And when we first heard about it, we were really excited about an additional way for the Evanston residents to have an opportunity to have their voice heard. And thank you for representing us. Thank you for teaching us. We should all pay tuition to him because we just had a lecture on the Illinois Constitution. And thank you to everybody who collected signatures. Thank you to everybody who signed. Thank you to the Evanston people who are going to support this on the ballot, because it is going to make it on the ballot in March. I'm really disappointed in this, because to me, like, I'm not a lawyer, and it's as simple as the objection says state law doesn't allow a binding referendum on a local question, and Arlington Heights has it in their law books. Like, how is that difficult? Confusing referendum question, that real estate transfer tax question was cuckoo. Like, that was very confusing. So the law and case law and Governor Quinn's box of cases prove that this is an invalid objection. So we'll see what the judicial review does. But obviously, it's clear to all of us, and I'm sure all of the people watching at home, that this was a political decision, and the decision was made ahead of time. And you might not like this, and that's okay. You can vote against it. You can campaign against it. You can do anything you want. But this is a voters' rights case, and it is a substantial right for this to be on the ballot. And this is Dr. Martin Luther King's birthday. Like, he got beat up on the bridge that we walked across together for voters' rights. Like, it's not cool to try to get this off the ballot. So I'm just going to quote something that Governor Quinn quoted from this case before. It's Arndt versus Haggerty. And I'm going to reword it a little bit. There is no question that not candidate Steve Haggerty, but the Evanston Voter Initiative has demonstrated more than the minimal appeal to the voters of the city of Evanston, having turned in not hundreds, but thousands of signatures in support of his candidacy. No, the initiative. Illinois law clearly recognizes under circumstances that there's no basis to remove it from the ballot. And that's going to be found in judicial review, and I'm sorry that we have to spend more time doing that because it would be really fun to start campaigning. I'm going to do that right now. Vote yes, everybody. It's going to be great. But this is just, it's really, really disappointing that this political decision was made tonight because that was not an unbiased thing. Like, I worked as hard as the objectors did, and I have the Honorable Pat Quinn as my lawyer. Like, I didn't work hard for this. He did all the work. This was supposed to be the objectors were supposed to prove their case, and that did not feel that way. So, vote yes, March 17th.
Thank you, Ally. Okay, that concludes our public comment. I know we've got some materials to hand out. I think Clerk Reed wanted to say something.
I want to make one statement. First, I want to remind folks that the objection process is a part of our democracy. This is democracy, so let's not forget that. And I greatly admire you, Alderman Grover, as well as you, Ms. Hayford. I don't know you, Mr. Swanson, but I'm sure you're an honorable person. And so I do want to thank you for, using your right as Evanston voters to bring this question. I enjoyed this discussion. I learned a lot about the Illinois Constitution and about this process. I spent last night up reading court cases, and I am better for it. So I do appreciate that. And to Ms. Harned, to Ally, and Governor Quinn, I appreciate the work that you guys did. That is democracy, circulating thousands of petitions. I think it was mostly over the summer, so you weren't in the cold, but it was cold. There are cold days, and so that's democracy too, and I highly appreciate that. And the one point I do want to make is this was raised in, when I was running for clerk, I read an article, I think it was from 2011, where the state was considering, or maybe where the state was considering getting rid of these local election boards. And I don't know if it made it into my campaign platform, and this isn't the place to talk about that, but I do believe that I hope in the coming years that we no longer have local election boards. The local election authority should not be made up of the mayor, the longest serving alderman, and the elected clerk. It should be an independent board made up of experts who understand electoral law. We shouldn't need to hire outside counsel. We should have an expert group. And if this is something that we have to go to the state about and get a law passed just for Evanston so we can get rid of local election boards, then we'll do it. Then we should do it. No, we don't volunteer. We're mandated to. Yeah, we're mandated to be. And to Alderman Rainey's point, we're mandated to be here by law. And so, and so I hope that that is. I know I will talk to our local representatives in the state house about changing that. I think we could have a much better system where a truly independent, non-political board looks at these cases and has expertise in this area. So thank you.
Thank you, Clerk Reed. Okay, I'm going to ask the council, what's the next step that you have here?
Next step is to go back on the record and serve the copies of the decisions on the parties. If you would, I'm going to pass the decisions out to either side.
Before we get the decision, I just learned that apparently you wrote the decision before the hearing. Is that true?
So just for the record, because of the expedient nature of these hearings, there were draft materials, a memo, and then a bunch of other draft materials prepared that included every virtual outcome of whatever this board decided.
Well, we'd like to see the record on that. Number one, we saw the special counsel act as the attorney for the objectors in the course of this proceeding. How can you call this an unbiased proceeding? He had already written your decision, and then he prosecuted it on behalf of the objectors. This wasn't fair, and you know it.
Yes, there is all of these. Again, I don't know all the rules that are around this, as you know, attorney-client privilege, work products, and everything else that we have here. So those are the materials that are here that are with the board, governed by that. Right. And just so everybody knows, the reason that these are hand drafted is so that, again, because of the nature of the time issue here, this way we don't have to come back. That's why a bunch of different drafts were put together. So this board does not. All right. Yes, there was. Yes. But I can raise it. It's all in here and all these papers that I have and documents that were sent to us. So I'm sorry that you don't believe me, but that is the situation. Okay, so we're now going to hand these out then to the objectors and the petitioners?
Sure.
These materials, okay.
Sure, we're going to serve the adopted decisions on the parties. I would, when you see them, I would ask you that you acknowledge receipt on the record.
Are we going to see, though, your pre-written material? Why don't we see that, too? That's part of your behavior.
We might need it for a court case. It would give us a good case law.
Thank you. Thank you. All right.
I think this is a very important point. If there is material prepared by this board, by your counsel, who is not retained by or not a member of the government of the city of Evanston, he obtained him privately, and then he wrote decisions on this matter before the case, before the hearing, including on the issue of these objectors not filing a valid objection. We want to see that material now. We're entitled to see it now because we're going to obviously vigorously defend our voting rights.
Well, you can certainly defend your voting rights. You know all the case law. You recited it tonight. It's all there. You're going to do it.
Yeah, where's your material that you prepared ahead of time? That's what
so again, it's all client attorney privilege material that this board board has.
Client.
The board is the client. The board is the client.
You don't have attorney-client privilege. No. This is public documents.
Okay.
You're a public agency. There's no attorney-client here.
We still believe we have privilege. So that's another argument you can make.
The material you prepared ahead of time before the hearing.
Just so we're clear, everybody presented their case tonight. You presented your case with all your rationale. Okay, I would argue that there's a legal disagreement, right, about what the Constitution and the law allows. You have a written decision from this board, okay, based on the votes of this board before you. You can look at that if you choose then to say we're going to take this to the circuit court or to somebody else, because there is another. You can go above obviously this board. You can refute that.
How is that based on the objection? He wrote something to you that wasn't based on their objection. He, in effect, is amending their objection. That's why you're not neutral, you're not impartial. You had a decision ahead of time, and you had commissioned him to write something for you before you even had the hearing.
Okay. And
these people prepared whatever they call their objection, did not argue their case. They used your special counsel to argue their case. Okay. This is fundamentally unfair.
Okay. All right, thank you. Okay. Is there anything else that we need to cover then? Is there a motion to adjourn?
We want a copy of that material. That's what we want.
Right now you're not going to get a copy of this material.
All right, well, let's show that on the record.
Okay.
Clerk, is it available from the clerk?
This is privileged to this board with attorney-client privilege. Okay. We'd have to talk to attorneys and everything else to release anything.
So, I will talk to attorneys tomorrow, and I do believe that we have the right to waive privilege in the interest of the public. That is something under FOIA that we have the right to do. So I'm not going to, I think I independently, as a member who received these materials, could waive privilege, but I hope that the board as a whole will make that decision, so I hope that we will.
But take a vote. Come on. You're hiding
I make a motion
material
to
that belongs
release
to the public.
all of the materials that were sent to us by the outside counsel.
Is there a second?
I would second that. I don't find any of it was.
Yeah, I don't think anything should be. Yeah.
I would vote no on that motion. Okay, so if we take a roll call on that motion.
I would like to know if this is a valid motion.
I don't think we should sit here in a meeting with something that's marked attorney-client privilege and just make a big decision. I think we need to think.
But we have the ability to waive privilege.
We need to think about.
We do. I know we do.
Okay, here's my position. If we do have the right to do that, I have no problem. But if we don't, then I think, they should FOIA.
Well, they couldn't FOIA. I mean, same thing would happen if they FOIA'd it.
So if they can if they FOIA it, then this board can make a decision about whether to waive privilege or not. At that point.
No, then
There are
it just
very
be
limited times to appeal this matter. You're hiding.
That's exactly why this attorney to the board prepared a bunch of different materials. Okay, so we could quickly do that.
After a impartial hearing, not before a hearing, and not with material prepared by the special counsel to assist the objectors. That's what's going on here. And that's why we want to see that material now.
Early voting starts February 6th, so
Okay.
I'd really like to get this
All right.
taken care of.
Sure.
And if you're saying it's not a political decision, then it should be easy.
Number one, he's paid by public money
Yeah.
for you, and you're a public agency. The idea that you can hide this material that's public to this hearing is preposterous. We're entitled to know what he was doing on behalf of them, the objectors, before the hearing.
So
But
we are
I
going.
object to your making that statement as though it were fact, because there is nothing here that we did for them. Nothing. And I saw what we did, and I'm telling you there's nothing. But I have no objection to you seeing what we were given. But if they were given anything that I don't know about, then I would object with you. But as far as I know, we have nothing here that was given to them. Nothing. I mean, that's an absurd statement.
The point, Alderman, is the special counsel cannot prosecute the case for the objectors. The special counsel has to understand the rules are the petition is considered valid. The burden is on the objectors, not on your board to make their case for them. That's what happened.
And that didn't happen.
Again, that objection
The petition was given to you before the hearing. Why couldn't it be given it to us now? Because we're going to be working hard to fight this in court. Like.
It is legal advice to the board, and so I think that a decision should not be made at this moment about turning over legal documents that are marked client attorney privileged. I feel very strongly about that.
If I may just ask one question before we adjourn, Mr. Boland, are we able to? We as the board, of course, have the right to waive privilege, correct?
Sure.
Thank you.
Well, I believe you had a motion and.
I made a
people
motion
voted for it
and
to waive the privilege.
Well, we didn't call a vote for it, but
let's call a vote. I do not.
So roll
you know
call.
my
I request a roll call vote on it.
Okay, so roll call vote on releasing this information right now, Clerk Reed?
Yes.
Suggestion right now to release this information, Clerk Reed?
Yes.
Alderman Rainey?
I don't know, is there information that I don't know about? What I know about, I don't have a problem with. But I don't know if you have information that I don't have.
All right, well, you're thinking I'm voting no.
I'm abstaining. Because I don't, I don't know what information we're talking about.
All right.
I'll give you everything I have.
All right. If she's abstaining and we've got a 1-to-1 vote, how does that work, Attorney?
So the time would go.
Something that I think is bad.
Obviously, this is over the advice of counsel, so but against the advice of counsel,
Right.
but if she doesn't say, I'm staying.
Okay. So I apparently need a vote from you, Ann.
But
You know the advice of counsel. Advice of counsel is not to release it right now.
Can two members of the board talk to one another?
On the record, sure.
On the record?
Yeah.
All right, so let's have a chat.
All right.
What do you see that is,
I think regardless of what I see, there's just been
everything that we've emailed? I mean, that's all I know about.
Right, and that's what exists, what we were emailed from Mr. Boland, both the responses from the objectors and the petitioners, but also the, litany of guidelines in the memo that he gave.
Motion to sustain.
Yeah.
To sustain Governor Quinn, you can make a motion to sustain the objectors. That's pretty much dialogue, right?
Yeah.
If you do this, then that, if you do this, then that.
Right. I think the, yeah.
I mean, that's not harmful. So
I don't think releasing it is harmful. I do have I had an opinion that it was, maybe some of it was inappropriate, and that particularly the one opinion that we have now adopted was the only fleshed out opinion, whereas the other ones were, not as fleshed out as this, not fleshed out at all. And similar with the memorandum that we received, I had that issue. That it wasn't unbiased in its presentation.
But there was no interaction with the objector.
No, I don't think folks are saying that the objectors had any special privilege or that anything illegal.
As their counsel, and that's not what was happening at all. That I could see. I think that the two principals should meet with our legal counsel.
Our legal counsel is gone as of, or will be gone as soon as we're done with this hearing. His duties with us will be.
Well, I think we should extend his duties, and our legal counsel should meet with the two principals and work this out.
When you say the two principals?
Meaning the objectors and the petitioners.
Alderman Grover and Governor Quinn should meet with our legal counsel and work this out. Everybody should see what it is that they need to see.
So is that
That's a motion.
Well, we have a motion on the floor, so we either have to.
Oh, I think you should withdraw your motion.
I'm not going to withdraw my motion. You can vote however you feel, but I'm not going to withdraw it.
I think there should be a conference between the three lawyers.
Can you speak in the mic?
I'm sorry, my mic is turned off. I said, I think the three attorneys, well, I'm out of order because we have a motion on the floor.
Yeah, so
right now
do you
we
want
have a motion to release these right now, all this materials from the attorney to this board, and it's 1-to-1. Clerk Reed saying to release, I'm saying not to release.
I'll say not to release so that I can make my motion.
So the motion fails.
So the motion to release the documents right
Ms.
now
Hafer had a question.
fails. Is there another motion? Alderman Rainey.
I move that that Alderman Grover, that Governor Quinn, and Mr. Boland meet in our legal department and discuss this issue so that we can move forward. There can be a negotiation. Because I think it's important that this get worked out, because I think the charges that have been made are very serious, and I think it should be worked out.
Here's what I'll do. I'll second that just for quick discussion on that. And I don't think that's appropriate. One, I don't, we have to pay Mr. Golan quite a bit
We'll pay him.
our tax.
This is worth paying him.
And
I think it's important.
And I suspect that this case may be moving forward to court.
I'm sure it is.
And so I don't know if we should use the city's resources to have that conference unless it's something that both the objectors and the petitioners really want to engage in. Otherwise, if just one group wants to do it, I don't know how appropriate that would be to have one group meet with the city-paid attorney.
Serious charge.
All right, but you voted for. He voted to allow it, though.
No.
For her motion.
I just seconded.
You just
I'm going to vote no to it.
Okay. So, all right.
If you want to do a roll call.
We'll do a roll call then.
I vote
Clerk
no.
Reed? Alderman Rainey?
Yes.
And I'll vote yes.
I mean, we can't make you do it if you don't want to do it. But I would just like to see this resolved.
What does that mean, resolve the issues?
A discussion among yourselves to see.
We want the documents. We're going to file a petition for judicial review. This is an unbiased, this is a very biased proceeding in the fact that your special counsel prepared ahead of time, before even hearing the motion to dismiss today, prepared arguments on behalf of the objectors. And we're entitled to see what he wrote to you. And that's simple as that.
He also
Now,
prepared arguments had you prevailed, right? So those exist as well.
We want everything. We're entitled to everything. He's paid with public money. You're a public body. You have no right to deny this. The Freedom of Information Act, by the way, says public information belongs to the public, not to you. And we're entitled to see it, especially to prosecute our appeal, so we protect the voting rights of the people who signed this petition, who passed the petition, who want to vote on the referendum.
Have you been to other electoral board hearings where a written decision's granted right at the end of it?
It happens all the time. This is a matter of great import. As was mentioned, early voting starts February 6th. You've denied people the right to vote in this referendum, this board. And this special counsel over here wrote material to you to help them. And we're entitled to know.
And wrote materials that would have helped you as well had you prevailed. And as you mentioned, this is a quick decision that needs to be made. It is common for electoral boards to issue written decisions at the end, and that was what happened this evening.
We saw by his behavior today that he did not follow the election law, which says the burden is on the objector, not on the special counsel for the electoral board. He took up that burden on their behalf. That's not right. That's not impartial. That's not fair. You let him get away with it. And we're not very happy with it, and I don't think voters should be either. The law wasn't followed.
All right.
Is there? You can see these papers.
We have to prepare our petition for judicial review. We're entitled to the full record prepared ahead of time by your special counsel against our interests.
Is there a motion to adjourn? Okay, we can sit here some longer. All right. Well, we did. Okay. Is there a second to adjourn? I'll second. All in favor of adjourning? Aye. Clerk Reed?
Aye.
All right. This meeting is adjourned. Thank you, everybody, for coming out.